Good morning. I'd like to call this meeting to order. The time is 9:02, and today is Thursday, September 22nd, 2022. This is the second day of a two-day meeting of the Physical Therapy Board of California, and we are meeting again at San Diego Mesa College at 7250 Mesa College Drive in room MC 211A. Can we please have roll call?
Alicia Benemin.
Here.
Tanya McMillian.
Here.
Dale Armstrong.
Here.
Jesus Dominguez.
Present.
Daniel Drummer.
Present.
Katarina Ellaby.
Present.
Jonathan Irvin.
Present.
All members are present and the board has a quorum.
Thank you. And if we can please ask Ms. Ellaby to read our board's mission statement this morning.
The mission of the Physical Therapy Board of California is to advance and protect the interests of the people of California by the effective administration of the Physical Therapy Practice Act.
Thank you. And we will jump right into agenda item number 22, which is an overview of the Attorney General's legal process for disciplinary actions with John Gatchett, Deputy Attorney General, and also want to acknowledge that Gloria Castro is here today, who's a supervising Deputy Attorney General. Thank you and welcome.
Good morning, everybody. I believe Jason has a brief little intro he was going to do.
Just that I wanted just to remind the board members that we're kind of returning back to post-pandemic traditions, and we wanted to do a training component for the board members at each and every event. We've had this presentation before, but it's evolved over time, so we just want to thank John for making this presentation today to give you kind of an idea of the services that the Attorney General's office provides to us in our mandate of consumer protection. So, thank you.
And so a little bit about myself. I'm a Deputy Attorney General 4. I've been in the Attorney General's office now for about 8.5 years. It'll be 9 years in January. Before I came to the office, I was a Deputy DA. I worked in Fresno County for 6 years, and I worked in Kern County for approximately 6 to 8 months. That was my first posting. So that kind of work was criminal work. I prosecuted domestic violence cases for the great majority of that time in Fresno County. Since coming to HQE, or Health Quality Enforcement, I've been doing this work, and so I've been the liaison assigned to you as a client now for approximately 3 years. Previously, and what that role entails. So our senior assistant, Gloria Castro, by statute is counsel for Jason and the board, and I serve in a way to act as a conduit for Jason to ask questions, or if Jason's staff have questions. Before we file a case, or if a case is filed, if there's a question about what we're doing in the process. I don't get involved in individual cases that have been assigned, typically. Those are for the DAGs that are assigned those cases. But instead, I'm more of a sounding board, and I act as a conduit for information. So information can get from Jason to Gloria. We have many clients in health quality enforcement. So that's a little bit about me. Health Quality Enforcement was founded in 1990. It was a cutoff from licensing. So DOJ, at that point, all the regulatory agencies were in the licensing division. And Health Quality Enforcement was created as a specialized unit to deal with medical healthcare practitioner licensing. So we have a number of clients. Our largest client is the Medical Board of California. But then we also have all of our other clients who are as important to us as the medical board, and you are one of those clients. You've remained one of our clients since that time, and so we really look forward to representing you in legal matters and litigation matters and disciplinary matters. And we try to do that and provide you the best legal services. In that sense, you're special because you're part of a specialized unit in DOJ. We only have attorneys that deal with healthcare practitioners. We don't deal with licensing matters for anything outside of healthcare practitioners. All right, so what I've done today, and this is a presentation I've done for a few of the other clients, and we've kind of turned it into a presentation for you, is kind of just concentrating on the physical therapy board. Let's see if I'm advancing here. There we go. All right. Generally, you have an idea of the powers of the board. You're a regulatory agency. You're not a trade association. You're not a lobbying group. You're part of the executive branch, right? So the governor's authority in the state of California carries through Department of Consumer Affairs down to the Physical Therapy Board as a regulatory agency. Well, what does a regulatory agency do? And I know that some of you are newer board members, have joined. I see a lot of familiar faces. I know some of you served on other boards. But regulatory agencies license practitioners in that practice. So we've got a list here of the powers of the board. The big one for HQE, or Health Quality Enforcement, is the discipline of licensees who have committed unprofessional conduct. When the board makes decision-making and goes through and prioritizes what it's going to do in its role, the number one priority is always public protection, public safety. Regulatory agencies serve a police power in the state, right? They serve the police power of ensuring that a practitioner is safe to practice, that the public is receiving quality care. The public has ways to reach litigation against a practitioner, for example, civil litigation, criminal litigation, but one of the primary roles in our society for a regulatory agency is to actually look at that license and provide, outside of the civil context, outside of the criminal context, a regulatory oversight over that. And you know, the DMV, the Department of Motor Vehicles, for example, regulates car drivers. Everybody drives a car. And you know, if you drive a car recklessly, you could be criminally prosecuted. You could get a citation. That's, you know, from a, but also DMV itself regulates that. DMV regulates drivers to make sure that you're, you know, trained, you're able to drive a vehicle safely, that you don't have any medical problems. And that's what the boards are doing. That's what the Physical Therapy Board is doing for physical therapists and physical therapist assistants. Making sure that they're trained, educated, making sure that when they're treating the public, that public protection is in place and carrying out those roles. All right, so what are some of the daily functions the board does that does not really involve us? I've listed them here. Typically, as you go through this process, you're going to be doing a lot of rulemaking, general administration. They don't really have our input. In fact, we'll talk a little bit later, but your DCA or Department of Consumer Affairs attorney, your legal counsel, will be the one helping you with a lot of this and advising you. And it really is in our place to advise in a lot of these issues. But our role is enforcement. So when you're looking at enforcement and you're going to have to litigate, that's where the Attorney General's office comes in. And so litigation is going to be those places where an accusation has been filed and the board is looking to discipline a licensee. Also, there's some other areas as well. If a licensee is on probation after a case has been settled, you'd be the ones that would handle the probation revocation hearing. If a licensee or applicant is seeking licensure and the board decides not to grant licensure, we'd be the one handling the contested licensure application hearing, which is a statement of issues. We conduct contested citation hearings. Typically, if a citation is issued by Jason, typically licensees will pay those, but if it goes to hearing, we do those hearings. We appear petition hearings. I know yesterday you had a petition hearing to see if someone could early terminate from probation. Our role in those is a little different. So in that situation, we're not actually representing the board or Jason. We're actually representing the public, the people of the state of California. But we will appear and handle those hearings. And then finally, if the board seeks a bail restriction, and we'll talk about it a little bit later in this presentation, we would be the ones who appear in Superior Court for a Penal Code 23 motion. We also, aside from this list, will represent you if the board is sued or if you are sued in your individual capacities. We will also represent the board if the board has a subpoena issued against it. And that happens from time to time where you'll have civil litigation going on and a plaintiff's counsel will serve a subpoena on the board for records. It'll be our office that will then defend the board in court and try to work through those resolutions. All right, so let's talk generally about the different types of burdens of proof. I know this is like lawyer type stuff. So if you're a lawyer, you'll understand this. And if you're not a lawyer, it's kind of, probably gloss over a little bit. What I just want to try to explain is where we fit in this. So everybody knows criminal proceedings, beyond a reasonable doubt. If you've watched Law & Order, you've heard that. Civil court proceeding, typically people understand that preponderance of the evidence, basically if the two scales are even and there's just a little bit of evidence on one side, a little bit more, then you've proven, and that's for civil liability, so like a car or a dog bite case. So administrative proceedings are a little different. We're dealing with a property interest, and so the due process involved in a property interest requires a finding of fact that's higher than preponderance of the evidence, but below a reasonable doubt. Could I tell you it's 70%? No, I couldn't. Could I tell you it's 80%? No, I couldn't do that either. There's really no chart. What it is, and Ettinger's up there, but it's evidence that, it's highly probable that a fact is true. The way that we use this in other contexts in the legal arena is if you take a child from a parent. That is clear and convincing evidence. So it's a much higher burden than preponderance of proof. We can say that pretty easily. It's not reasonable doubt. It's somewhere in between. But it is a higher burden of proof, which means that our evidence needs to be a little bit stronger than a civil case. It needs to be clear and provide the fact finder, which typically is an office administrative judge, a reasonable belief that, yep, that fact is true, and true beyond just a little bit of a scale, but actually weighing down. The other part that we have preponderance is if it's a statement of issues case, it's actually the burden of the applicant. So when you deny a license, it's on them to prove by preponderance of the evidence that they are eligible for an application. Same with the petition case. So the petition case you had yesterday, burden of proof is different than it would be in a administrative proceeding to actually take away a license. All right, up here I've put some statutes. These are common statutes that we deal with for accusations, when we file an accusation. 2660 subdivisions A through X is where kind of your codes live. It's a very exhaustive list of all the things that an applicant or a licensee can do that's inappropriate. I've kind of broadly listed some of them. Your code section, because you were once part of the Medical Board of California, allows you to use the Medical Practice Act. There are a few codes that still live in the Medical Practice Act that are actually better or at least provide more robust legal theory. 2239 is one of them, and that's the use of alcohol in a dangerous manner, just because the case law on 2239 is pretty set forth. So sometimes we'll charge those in the alternative. We'll have a 2239 with 2660, the subdivision that's dealing with alcohol. Another area is the Moscone-Knox Professional Corporations Act. In California, the board is able to regulate licensees who violate Moscone-Knox. What is Moscone-Knox? Moscone-Knox is an attempt by the legislature to remove the corporate practice from medicine or healthcare practicing. So the idea of people that would not be physical therapists starting a physical therapy corporation, setting the parameters, setting the standard of care, and then hiring physical therapists to work for them and dictating to those physical therapists how they're supposed to treat their patients. California, one of the stronger states in this area of the law. For example, like a state like Texas doesn't really concern themselves with such things. California has made this a mission to protect the consumer and protect the consumer from that kind of practice. And so you can't be a limited liability company in California and practice under the Moscone-Knox Practice Act. You have to be a standard corporation with flow through, and you have to be controlled, majority controlled by physical therapists. Also, you have various regulations that contain discipline as well. You guys have some great statutes or regulations under 16 CCR 1399.24. That regulation is better than some of our other clients, where it requires arrest and conviction reporting requirements to the board. Some of our other clients don't have that in their regulations, and so sometimes licensees forget to report that they've been arrested or convicted. Your board actually requires that and makes it unprofessional conduct if it doesn't occur. All right, we've added this slide. This is also a big area, and probably for a public protection area, 820 is probably one of the bigger pieces for public protection. This area of the law has to do with whether a physical therapist, a licensee, is safe to practice, and if they have a mental, physical impairment. Those can be, mental. We think of schizophrenia, bipolar. Those also can be substance abuse. So if a licensee is using drugs in a dangerous manner, and then alcohol, dangerous manner, they may be to be looked at through an 820, which is a petition. You can compel an examination. That petition would go to Jason, and the board has delegated authority for Jason to vote on that or to sign off on it, and then we can go ahead and have someone actually examined by a health practitioner specializing in that care, either a psychologist or a psychiatrist. If a licensee refuses that examination under Business Process Code 821, their license is revoked. They don't get to challenge it. If they choose to fight the request for the examination, that will lead to an accusation, which would lead to the revocation of their license. There's a couple cases on that, gather being the most recent. They're not even entitled to see what the petition says when they refuse. The courts have kind of looked at this as this is an investigative process. It's not a disciplinary process until you put your foot in the sand, and at that point, then you're facing discipline. Yes?
How's that order enforced? Is the licensee turning in those medical records or whoever they're seeing? Is that what happens?
That's correct. So the order that's issued by the board after the petition, or the order for compel, that order will include in it that you turn over your records. And if you fail to turn over your records, then we would be looking at as an agency to see if we have the evidence to then move forward with an 821 if they refuse to turn over their records, because they would at that point be refusing to take part. 820 has a number of protections in it. So if a licensee is examined and they pass the examination, the report and everything is a part of that is sealed. It cannot actually be subpoenaed. It cannot be turned over. It basically disappears. So that's the part that the Superior Court looks at when saying, well, is this a fair process? The fair process is this is an investigative step, not a disciplinary step. And so it gives the board a great deal of leeway to order that, but it also protects the rights of the individual if they do actually pass the examination. If they fail to pass the examination, then at that point we would be bringing disciplinary charges under 822. One of the questions we get a lot is, well, why can't just a licensee retire from the practice of physical therapy? For example, if they're older, they start having dementia, why can't they just turn in their license? Unfortunately, when they retire, there would be nothing to prevent them from reapplying for licensure. So that is why, even if we have a licensee that would like to just turn over their license, we will often bring discipline. That changes the burden of proof. Go back to the application process. Application is preponderance of the evidence. If we make it so that their license has been surrendered or revoked, then they have to prove by clear and convincing evidence and petition for reinstatement, much higher burden of proof, that they're able to get their license back. And so that's why we push those processes. All right, and then we were covering at the end there, if the expert does find an impairment, what happens next? Well, we have a hearing. All right. What about a licensee who poses an imminent threat? And this is where the board can institute, through our office, a much faster process called an interim suspension order. So an accusation will take time. We try to speed those as much as we can. Gloria makes sure that our unit has very defined timelines for receiving, reviewing, filing, and setting cases for hearing. However, that is still going to take months for it, based on OH calendars for review. One of the processes we have that can turn into days and weeks is the interim suspension order. If a case does merit this, and it is looking like someone is posing an immediate risk, we will pursue this. I've done this on behalf of the board a number of times. It is a temporary restriction that stops practice until a hearing on the merits in the accusation case. Lower standard of proof for the ISO, it's only a preponderance to get the ISO. However, it will push a disciplinary case into a statutory timeline that is much faster. So one of the things that we do when we look at an ISO is we make sure that all of the evidence is in place, that we're not going to have to be doing any further investigation, that there won't be any surprises, because once we take this step, in order to take this path, it does require us to move very quickly to a full hearing on the accusation. So that's interim suspension orders.
I have another question.
Yeah.
Can you just give us a simple example?
Sure. So one of the examples I did, I believe, was a licensee out of North State, and what we had was a situation where he was on probation for alcohol-related situation. He picked up 2 more alcohol cases. he was still practicing. And under that situation, because we had him on probation for alcohol, we had 2 new cases of alcohol, there was a concern that he was an alcoholic, a habitual alcohol user, and under those circumstances, it was deemed that an interim suspension order was, for public safety, was important. It was approved, and then we went forward on that. So those are the kinds of cases we're looking at.
Just what I might add to that is that maybe something a little bit more crystal clear is if the licensee demonstrates as being kind of a clear and present danger to the public, whether it be a violent crime, arrested for something in the nature of sexual assault or assault and battery, or even like an armed robbery, where we have a very real concern for public safety today, and we're able to compel an ALJ or a criminal justice attorney to see it our way also, to say that not only is he should not be on the street as Joe Citizen, but he also shouldn't be practicing under the license.
And so this is where we have 2 avenues at play, and so we're actually going to cover it in the next one. So Jason brings up crimes. One of the other ones for ISOs too is when we have clear evidence of impairment for like mental impairment. I've sought ISOs for people that have dementia, Alzheimer's, and in those situations, if they're not moving very quickly to surrender their license, and sometimes they will, we seek an interim suspension order because if they're treating patients. In the criminal context, if we've got a criminal case pending, then we will also look here, which is a Penal Code 23 bail motion. ISOs in criminal context, at least with sexual assault cases, can be difficult because an ISO will put us in front of the criminal case. And sometimes we want to be careful with witnesses, especially sexual assault witnesses, having them testify before a criminal case. Anything they testify in the administrative case can then be used against their testimony and credibility in the criminal case. And so if it is an option, and this is something we have to balance, and we speak with Jason about that, which is the best way to go, either an interim suspension order or a bail restriction, we'll make a decision talking about the type of case. So we have Penal Code 23 available to us, and that is, the 2 cases are listed there, Gray and Nadeau, but that is a motion that we make in Superior Court on your behalf, petitioning the Superior Court to issue a bail restriction or an own recognizance release. In criminal court, we call that ORR or OR. And what that would do is then prevent that person from practicing by order of the Superior Court. So their license is not surrendered, their license is not suspended, but it is an order by the Superior Court saying, if you practice, you'll be in violation of my orders, and then I can either remand you back to custody, or, well, that's basically what would happen. They'd remand back to custody. So it's pretty powerful. If a licensee violates an ISO, an interim suspension order, we have code sections that say, well, now your license will be revoked. There's actually a code section that says that if you practice during an interim suspension order in the Medical Practices Act. However, that just means that it's a court saying down the road we're going to revoke you, or administratively. We're actually limited. We can't put someone in jail if they violate an interim suspension order. The difference is if they violate a Penal Code 23 order, that Superior Court judge can put them in jail. So sometimes this has more teeth than an interim suspension order. But also coming with that, sometimes Superior Court judges are less likely to grant us this order. So it really kind of depends, and so that's where we try to strategize which is the best way to go. I've had situations, I know I had a case up in North State, we sought a Penal Code 23 order, it was a sexual misconduct case, and the judge heard it, didn't grant it, put it off past the preliminary hearing. So under that, we then said, okay, this isn't working, so then we went back and we got an interim suspension order to stop practice pending the criminal case. Sometimes you have to use both. So, all right, licensing. So in licensing, when an applicant comes, the board has a number of different paths it can choose. It can choose to issue a license. It can choose to issue a license subject to terms and conditions. It can deny the license. This is an area where the law is still kind of changing or in flux. It's not the same as when I started practicing. We've put a lot of limits. The legislature has put a lot of limits on what can be used to deny a license, especially if it's a past crime or the acts around that crime. And so, we try to do a good job of looking and following the statute as it's written under 480. But this is an area that has kind of changed somewhat, but this is basically licensing. And then if you deny a license, it would then go to a statement of issues. We would file a document with OAH, and then we would have a hearing on that, with the applicant having the burden to prove that they, by preponderance evidence, are eligible to have the license.
I had a question.
Yes.
So if we do an ISO and we say, hey, pending your criminal investigation, we're suspending your license, and then they become innocent, they're proven innocent, are we going to be liable for suspending that license for that period of time?
No, because burdens of proof. So we are operating under a preponderance of the evidence standard. We're a much lower burden of proof for an ISO than a criminal case. Criminal case is beyond a reasonable doubt. In fact, a board can take discipline against a licensee for the underlying acts, even if a licensee is later acquitted in criminal court, because even in a disciplinary proceeding, our standard of proof is clear and convincing evidence to prove, which is a lower standard of proof than beyond a reasonable doubt. So there's no liability to the board for taking action on acts that rise to a criminal case, even if the criminal case later on is found to be an acquittal. That's for licensees. Now, it's different for applicants, and that's has a lot to do with 480 and the changes to 480. So as of now, under 480, if someone were acquitted in a criminal case, we would not be able to use the acts to stop or deny their license. Does that answer your question?
One of the issues with using either of those tools, either a PC-23 or an ISO, is we're still respectful of due process, right? So those pseudo suspensions are in place while we kind of battle out the administrative process as it pertains to the license. So while it's kind of a temporary pause for the respondent, and we're saying you can't practice, we see that there's a clear and present danger to the public, that suspension is only there while we kind of prove our case in the administrative courts. And then, to John's point, the burden of proof really is where you might have a local district attorney who chooses not to prosecute because he doesn't believe he can meet that clear and convincing threshold. If he had the option, or I'm sorry, the beyond a reasonable doubt threshold, if he had the option to do clear and convincing, he might. Well, we do, right? So because ours is a little bit less, and we're not talking about violating anybody's civil liberties, we're talking about essentially revoking an authority that's given with a license. We're not restricting them as a person, just their license only.
Their ability to work.
That's why, well, their ability to work, doing something that they've, demonstrated proficiency at a minimum level, through this board and its application process, right? So we're kind of the gatekeeper coming in, the enforcer during the time, and so at that level, we have a little bit different administrative burden, right? Clear and convincing. So we're, again, like the district attorney might not have the option, he doesn't believe he can build a case that's winnable, and so he chooses not to prosecute. We could still pursue the underlying acts. We still have a concern, because our concern being good faith in consumer protection, right? We're looking at advocacy for the consumer and determining whether or not that licensee is safe to practice. A little different.
Okay. So what can a board do in a disciplinary case? I've listed a whole bunch of things that can carry out after a disciplinary case or to settle a disciplinary case. At the very top, or very lightest, is a non-disciplinary remedy. The board can issue a citation and fine. Disciplinary remedies, and up there it says impose a public letter of reprimand in lieu of formal discipline. It really should say in lieu of formal probation, because a letter of reprimand is disciplinary. It is part of a record for a licensee, and it can be used in the future should a licensee have more cases or new cases. So the board could impose a public letter of reprimand. Actually, I'm going to take that back. Public letter of reprimand, this is 2660.3. This is in lieu of formal discipline. This is Jason's power to issue a letter. Public approval is actually what I was just talking about, so I'm going to correct myself. Public approval is disciplinary, and that would be like a public letter of reprimand for the Medical Board of California, but under your statute, it would be 495, a public approval. So that's a lower threshold, a lower part of discipline, but it is discipline on a record. The board can revoke and stay and set probationary conditions. Those are set forward in your disciplinary guidelines. This board does a really fantastic job of keeping its disciplinary guidelines up to date. I applaud you for that. Some other clients sometimes have longer periods of time. So thank you for keeping your disciplinary guidelines up to date. That can include a suspension period as part of that. And then finally, the board can accept a license surrender or revoke a license. And obviously, going back to the question about work and property interest, that would be the largest penalty that the board can impose, which is imposing and taking away someone's license. Even if the board takes away a license, there is an opportunity for someone to petition and obtain that license again through a petition for reinstatement after a period of time has passed. Yes?
Can you please distinguish between the public letter of reprimand and the public letter of approval?
So we don't issue the public letters of reprimand. Those come from Jason. So I think that he would probably be in a better position to explain that. A public approval is disciplinary in the sense that it sits on their record. So I'll turn to Jason on the.
So through the delegation of authority that this board has granted to me as the executive officer for what would be considered kind of a razor's edge between something that raises to the level of a citation or rises to the level or threshold of discipline, this board's delegated the authority to me to offer into stipulation what's called a public letter of reprimand. And so kind of trying to deal with things at the lowest level possible, I can present the respondent, this is where we're at. We know that it's discipline. I can offer you these terms and conditions, education courses, cost recovery, those kind of things. If you're willing to accept that at this lowest level point of discretion, then we have a deal. We're going to do a public letter of reprimand that's issued by me. It never comes before the board. And again, it's part of that delegation of authority and the powers that this board has granted to me as the executive officer. So there's certainly a trust relationship there in doing it, and I have to make sure that I wield that sword and shield responsibly. I don't use it for the wrong reasons. I don't use it for egregious cases, those kind of things. Should the respondent refuse to enter into that agreement and accept a public letter of reprimand, we would file an accusation and we would go through the normal disciplinary process. We would make our case.
Which would then bring us to the public approval, probation, surrender, license, or revocation process that we would be then involved in.
Thank you.
Oh, no problem. All right, I've just listed a whole bunch of statutes. I've tried here on this slide to rehash, but basically listing out kind of what the general cases are that we deal with. So that's what this slide is. Without statutes, because I think sometimes when we see statutes we get kind of glazed and get tired. So this is just kind of a list if you want to go back and refer to some of the things the board deals with, setting forth. Okay. If a crime occurs, how is that related to the practice of physical therapy? Not every crime is going to necessarily result in licensed discipline. And so this kind of goes back to that question of, well, what happens if someone has a crime, they're found not guilty, and then there's a disciplinary action going on. There isn't necessarily a guarantee that any crime that's committed will be related to the practice of physical therapy. We do have to do a legal analysis and make a determination. For the most part, the regulations for the board are pretty expansive. So if the crime includes but is not limited to violating the Physical Therapy Act, the Medical Practices Act, or as a conviction of a crime involving fiscal dishonesty, it is going to be substantially related to the practice of physical therapy. That said, we do need to create a nexus. Griffiths has the idea here that for the most part that nexus will be established if it's displaying a license to protect the public, and the conduct of the crime is related to the practice. Typically, things like high BAC DUIs, typically alcohol impairment, sexual misconduct, murder, robbery, financial fraud, those are all substantially related to the practice of physical therapy. Animal cruelty, child endangerment, those are related to the practice of physical therapy. So most likely, yes, a crime will be substantially related. However, there could be a crime that might not be. This would be one of those areas that the legal analysis from our office in working with Jason and his staff would work through that. All right, conviction of crime, impact administrative cases. I put up here a couple just kind of cases to give you an idea how these kind of interplay. A plea of no contest is treated the same as a plea of guilty. Being a prosecutor, I'd say 90%, 95% of cases in California end up in a no contest plea or a nolo contendere plea. That's the Latin. That is very common. It doesn't matter for administrative purposes whether it's a guilty or a no contest. And then the privilege against self-incrimination. So this is your Fifth Amendment privilege. We hear when people say, well, I don't want to testify because if I testify, it can be used criminally against me. Administrative licensing proceedings, California has some very set rules on this. You can't necessarily use the fact that they're invoking against them, but you can use the fact that they're invoking and not giving a statement to give alternative testimony against them. So I know it's kind of a crazy way to unpack that. But for the most part, you don't have a Fifth Amendment privilege in administrative proceedings, which means the board comes to you and asks for an interview. As a licensee, you need to have an interview with the board. If you choose to use the Fifth, you can assert that. That is your right in the U.S. Constitution if you feel that your statements will be having criminal consequences. However, if you choose to use that and then we go to an administrative hearing and you've decided to use that right, we can use the fact that you have been silent to provide alternative facts in assessing whether or not the evidence that we're presenting is actually truthful. So, all right, use of alcohol or drugs. Watson is listed here. There's been some other cases that have come out. Sullivan versus Nursing Board was a case more recently than Watson. For the most part, driving under the influence of alcohol, whether a conviction or not a conviction, Watson, they were not actually convictions. But the use of alcohol, if it's affecting the practice of medicine, or in this case, the practice of physical therapy, and you have a statute as part of 2660, a subdivision called habitual intemperance. If you're using alcohol in a dangerous manner, that can be a basis for discipline. You don't have to wait until you're drunk with a patient. You don't have to wait until you're intoxicated and let a patient fall down. The idea behind these cases and the line under 2239 is that the board can take action if there's evidence outside of actually in practice that you're a habitual alcohol user. The board can take action to ensure that you're safe to practice, to ensure that you're not impaired when actually treating patients. All right. Here's a slide on negligence. This is obviously an area that we get into a lot on our cases with, whether they involve incompetence, gross negligence, repeated negligent acts. A couple of notes here from the civil context to the administrative context. In the civil context, if someone commits one simple act of negligence, and it's the causation of injury of that person, so let's say a physical therapist causes one act of negligence, it is the cause of the injury that they serve, and they have an injury, that is sufficient for liability in the civil context. The administrative context is different. It's different in these ways. One, it does not require harm to a patient, ever, for an administrative case. An administrative case, whether a patient was harmed or not, is irrelevant to the analysis, because administrative, and when you're looking at regulations, we're not trying to remedy harm, we're trying to prevent harm. So we can seek discipline on cases where a patient was not harmed. Now, there is a corollary, though, to make it under the due process, to make it fair. We also require two acts of negligence in order to move forward, a repeated negligent act, which means that they cannot be one act. We also have a higher burden of proof. Go back to that clear and convincing. Remember, when we were talking about civil, lower burden of proof. So removing back that, that injury component, that causation component that you don't have to have in administrative, there is higher burdens of proof. It also is not simply one act of negligence. Gross negligence is reckless conduct, and so we'll see that as well. And then finally, incompetence probably is the hardest of these three to prove. For the most part, people that are trained, qualified, have licensure, have knowledge of the practice that they're carrying out. I tried to come up with an example for physical therapy. I'm still struggling with it. In the medical context, where you would have this is if you have a family practitioner who decides to start doing cosmetic surgery in their basement, that's incompetence, right? If they have never received any training and they're doing, liposuction in the basement of their house under local anesthesia, that would be incompetence because they don't have the training to do it. They're doing it in an area they're not supposed to. Although there would probably be some doctor experts who would even say that was not incompetence. So that's kind of where that is, and that's kind of the gradation of those on the standard of care. All right, so here I've done this, I've set this up so that we can all issue spot together, and I'm deputizing all of you to be deputy attorney generals for the next 10 minutes. Don't tell Gloria I've done this. I think it's illegal. All right, so what we've got here is a hypothetical. I'm going to read it, and then let's issue spot it. Patient 1 makes a complaint to the board that physical therapist B appeared intoxicated during her treatment session. Patient 1 alleges that he slurred his speech, treated her left leg despite a medical referral for treatment of her right knee following surgery, and he stared at her chest for approximately 30 seconds during treatment. So this isn't like a glance. This is like a full-on stare. Patient 1 was uncomfortable during the appointment. So I will throw it to my deputies here. Who here sees an issue that maybe is something we should probably investigate? Issue number 1. There's 3 in this paragraph. No volunteers? Oh, we have one. Ms. McMillan?
He treated her left leg despite the referral.
For the right knee.
Yeah.
Great, and that is definitely an issue in this hypothetical. So that is a issue that if I were a DAG and looking at, okay, that's a standard of care issue, right? That's do I have a repeated negligence? Do I have gross negligence? That's probably gross negligence. It's pretty reckless. You've been given a referral and you're treating the wrong body part. Okay, we've got one of the issues. We've got 2 more to go. Yes?
Intoxicated, appeared intoxicated?
Appeared intoxicated, slurred his speech. So we might have an 820 issue. We might have a habitual use of alcohol issue. We might have a 2239 situation. Okay, so we've got an alcohol issue we've got to investigate. That's number 2. Number 3?
Sexual misconduct.
Sexual misconduct, right. And the board has a number of different ways to go after that. There's a subdivision in 2660 involving sexual harassment, sexual misconduct, as well as 726, which is a general that all the boards have. Okay, so we've got our 3 issues that we're going to now look at. As DAGs, when we get a case, and as you are my DAGs now, as we get a case, we're going to open up that case, we're going to have a memo from the board, and the board will have on that, Erica or one of her people, staff members, has written out, this is what we like allegations on, and this is what we've been investigating, 1, 2, 3. All right, well, I need to look as a DAG and verify that, yes, the investigation has actually looked at that. So in an investigation, what a DAG is looking for is what evidence has been obtained. In this case, we've got our 3 issues. Well, we definitely are going to want medical records because we have the referral for treatment of right knee following surgery, so we definitely want that. We definitely want to interview the witnesses. We have a patient who has stated that there was sexual misconduct or sexual harassment. So that patient needs to be interviewed. The respondent needs to be interviewed, the licensee, because often in these situations they are he said, she said, or he said, or she said situations. So we need to talk to the parties involved. We also are going to want to actually interview other parties that potentially are there. So the scheduler, the receptionist, any physical therapy aides. Physical therapy clinics often have not just physical therapists, but physical therapist assistants and physical therapist aides. Massage therapists can be in a physical therapist clinic. Sometimes occupational therapists can be there. Anybody that's there, we really kind of want to talk to. We also want to talk to the patient about who maybe the patient talked to, because if they made a complaint shortly to law enforcement or to a family member right after this incident, that helps corroborate that this occurred. Okay, so that's where we're looking. And then the part about the alcohol, well, has he been alcohol tested? Did we run down how we knew that he was intoxicated? What evidence was there of that? Did they go in his office? Did they see alcohol bottles? Talk to other staff at the clinic. Does he show up drunk all the time? We've prosecuted cases based on witnesses saying that a licensee is, using alcohol or has appeared under the influence over a period of time, even without having necessarily an alcohol test. Because once again, we're establishing credible evidence. If we can get to that clear and convincing standard, we will, and we'll put on that evidence. All right, after the investigation is complete, DAG's going to look next. Did it go to an expert? Board is going to hire a physical therapist to review this case, someone licensed with an understanding of this practice area. They're going to review it. They're going to render an expert opinion. Expert opinion on this, we're going to obviously need for the treated left leg, despite the right knee, and we're also going to need the sexual misconduct. That there would be no reason in treating a leg that licensee would need to be staring at the chest of a patient for 30 seconds, that would be outside the standard of care for a leg injury. All right, so that's what happens. Now we go to how this is done. We would file an accusation. So when the case arrives to us, if we agree that, yep, the evidence is there, we've got clear and convincing evidence, we can move on. You would be writing that accusation. We have a template that pops up in pro-law that starts the process, but the template requires you, the DAG, to actually insert all the factual information. We're going to put in that factual information about why there's a standard of care violation, and then we're going to say at the bottom of that accusation, and you've seen these documents, the 3 areas that we issue spotted, right? We're going to have issue spot number 1, alcohol use. We're going to have issue spot number 2, standard of care. Issue spot number 3, sexual misconduct. And it'll be cause 1, cause 2, cause 3 for discipline, referring back to those factual paragraphs, and then that will be signed by Jason and filed on the licensee. What happens next? Well, if the licensee does not respond, they have a very short period of time to respond, a default will be entered against them, their license will be revoked because they've waived their due process rights. In order for a licensee to have a hearing, they've got to tell us they want a hearing, so we serve their address of record, which is the legal address they are lawfully required to keep updated with the state of California. It is the only address that we have to serve because under a licensee is aware that they have to keep their address current. If they do not respond, then that's looking at a default. If they do respond, they file something called a notice of defense. Notice of defense will set forth that I would like my hearing. At that point, we set the matter for hearing, and we will have a couple other ways to resolve that hearing. Either we will go to a stipulated settlement. Many of our cases do resolve in a settlement. Or we'll go to a contested hearing. In terms of stipulated settlements, Frankel is the case that says that stipulated settlements are within the board's purview. The court case in that was deciding that if the board has the ability to go to a contested hearing and impose sanctions, the board has the implied authority to issue and enter into a settlement. Yes, ma'am.
When you said they have a short period of time, it's a short period of time before they're served and for them to respond?
Notice of defense has to be filed, I believe it's 10 days after service of the, but we don't actually file the default right away. I do want to clarify that. We are careful about the due process rights of people. We understand things happen. In California right now, we've had fires, we've had natural disasters. Sometimes even if your address of record says where you're at, DAGs don't go out of their way to file a default right away, and Jason doesn't process one right away. I know when we had the fires up north last year, I had a licensee who had to be evacuated for 3 weeks, and I waited. I sent her, and we sent an additional letter to them, so it's not quite, outside of the statute, our own office has created a notice of default, which we send out. It's a letter, it's not the default itself. It says, hi, you've been served with this accusation. Your notice of defense was due on such and such date. We are going to proceed with the default unless you respond to that. And so we try a number of times before we actually begin that default process. I hope that answers your question there if that wasn't clear. We don't want to default a licensee, and we are aware that natural disasters occur. We are aware that things occur within reason. Your address of record should be updated, and if something does happen like that, you do have the ability to reach out to the board and say what's going on and update your address of record. So hopefully that answers that question.
John, do you mind if I add to it just a bit?
Yeah.
As the complainant and the administrator of the board, we try to exhaust every effort in reaching out to a licensee, whether, our obligation is only to reach out to that address of record. Our analysts will, in their due diligence, look for online connections, emails, other addresses listed in public forums, those kind of things. We'll try to do everything that we can to make sure that that person knows that they're involved in an administrative situation with the board. So much so that I'm so confident in that when it does get to that level and we do go to a default, I have solace in knowing we did everything that we could to be fair and due process towards that response.
And when we file a default, Gloria wanted to bring up a point as well, motion to vacate. So even if we file a default and there is a default that's being put in place, there are statutes in place to allow within timeframes for a licensee to then file a motion to vacate and remove that and then go back with their hearing. Whenever we file a default, I file a declaration as a DAG, for example, that cites all the process that I've done and all the process the board has done to the board. Because Superior Court review, if it is challenged later, it can still be writ to Superior Court. If it's challenged later, if that's not present, a Superior Court judge will probably vacate the default. So there are a number of protections in there that protect the licensee. So it's a really great question. Okay, so we go to hearing. If we go to hearing, we either settle a case, we go to contested hearing. The board, your role, you'll receive the case after the contested hearing. So you're the reviewer of all final decisions. And so whether it's a stipulation or whether it's a hearing, the board will take a vote on whether adopting or non-adopting the stipulation or the hearing. That's where you're the final arbiter. We're going to talk a little bit more about this in a bit. You know how I had said earlier that the board was part of the executive branch? Well, when you're actually sitting in this role, you're still part of the executive branch, but your role changes a little bit. You become quasi-judicial because you now are actually basically arbitrating the final decision that a litigant, myself on behalf of Jason at that point, as the complainant versus a licensee or respondent, you're making a judicial, a quasi-judicial function at that point. You're not going to have communication with me. You're not going to have communication with the litigant, the respondent, because now you're acting in that judicial function. So although you're still part of the executive branch, you actually take on a quasi-judicial function. And then finally, any decision the board makes is not final. We have due process guarantees that allow for review of that. And so that can be reviewed through writ to Superior Court. And if the Superior Court renders a decision that either side doesn't like, we can writ as the DOJ on behalf of Jason. And actually, at that point, it'll be back to you making that decision. Or if the respondent doesn't like it, which is usually where an appeal comes from, there can be an appeal to a higher level of process to a higher court. Okay. All right, so we talked about settlements. Majority of the cases do settle. Your staff, through the board, through Jason and Erica, and the staff that work with Erica, provide our staff with a reasonable settlement offer. We will provide some recommendations or suggestions, but typically it's driven by board staff on what the offer is. We convey that offer, and then we convey counteroffer. So we work with the staff to try to see if we can reach a meeting of the minds or a settlement. Cases can sell for lots of reasons. Evidentiary issues, mitigating circumstances, evidence of substantial rehabilitation, witness issues. And so we will, when we send the case for recommendation to adopt that stipulation, we will put forth our legal analysis of why this is a good stipulation, sitting with your disciplinary guidelines based on the strengths or weaknesses of the case. Finally, on the bottom there was been some question or clarification on admissions. What is the distinction between admissions? So on a stipulation, we can ask a licensee to make full admissions. I fully admit everything that is here in the accusation. Or we can have soft admissions, and that's a negotiation tool that we often enter into with licensees. A clawback term is basically if the settlement is ever used, so that settlement becomes an adopted order of the board, if that settlement with that soft admission language, and that's where you'll see something like the licensee agrees there's a prima facie basis for this settlement, or the allegations in the case. That clawback term then allows all of the information in the accusation to be fully admitted for the purposes, for other legal purposes. So, from a legal standpoint, whether someone enters full admissions or soft admissions, as long as there's a clawback provision in the stipulation, which we are required by our policies and department policies to have that there, they're legally treated exactly the same. And where that would be important is if someone has a violation of probation while they're on probation, or their license is revoked and they seek reinstatement, we're going to want to make sure that the accusation that was there and the decision in order, that all of those allegations are true and correct and fully admitted for those purposes, because we do not want to be fighting factual disputes later on. We fight factual disputes one time, that's when the case is first filed. So that is stipulated settlements.
I have a couple questions.
Sure.
If you could help me. Just wrap my head around everything in the process. So before the accusation's written, staff has done what they need to do. They're familiar with putting something very sound before you to take a look at it. And then you and your office looks at it and says, yep, staff, we're going to write this accusation. Jason signs it. When it gets to the stipulated settlement, what's the sequencing? Because we aren't there. You're sitting down with the parties. Have you already spoke to someone from the Attorney General's office, or are they sitting there with you?
So there's a multitude of models based on the different variables that are involved. Sometimes we know from the point of accusation forward that we're intending to stipulate because we think it's appropriate given the circumstances. There are times where, for principle's sake, when I've sent an accusation over to the AG's office, and the AG's office is essentially vetting that accusation and saying that we've met that clear and convincing evidentiary standard, and they agree, and they issue the accusation. For principle's sake, I have no intent of ever entering into stipulation, right? There's something about the case and the variables where I think that should come before you as the board or an administrative law judge in hearing. So it's kind of it depends on which way it turns at that point. If we determine that, from the outset that it is something that's appropriate for settlement, we're going to try to deal with it at the lowest level possible. You've heard me all say this at some point. I enter into those negotiations with 8 voices in my head, right? My voice and each individual's voice as board members, because I know in drafting that stipulation there are going to be things that each of you are concerned about. And I want to make sure that I'm utilizing that trust that you've installed into my staff and to myself in drafting that stipulation. Once we move forward with that could enter into a negotiation process. We've said, here is what our stipulated settlement looks like. This is what we're willing to accept. The respondent's counsel might come back and say, we have a counter offer. There are a few issues that we want you to consider, supervision levels, these kind of things, trying to anticipate issues and trying to keep that person in their current place of employ, as an example. And so we might look at those, and there's going to be a point where, because of the threshold test of consumer protection and public safety, that we just say no. The negotiations are done. We can either agree here or we can go to hearing. And so the Attorney General assists us in a lot of that communication. Some of those things play out in settlement conferences that are scheduled before the hearings, and at times we are present, at times it is over video conferencing, and those settlement conferences can happen before an independent attorney or an administrative law judge also, to kind of just facilitate the negotiation between the state and the respondent. But it can be a multitude of different models.
And if you go into a stipulated settlement, there's agreement, then you put it before the AG's office and say, this is what we agreed on, and you write it up and make sure it's sound. And
Right. So I'm going to add a little bit too to this as well. I mean, Gloria wanted to point out it works backwards from the hearing. So the timeline, when we file an accusation, that is a moment in time that we believe at that point all the evidence that we have at that point shows that by clear and convincing evidence a case can be proven. Let's go back though to our example. Let's say you're the DAG on this case, and I went too far. Get there. There it is. Let's say you're the DAG in this case, and now you go to present this case for hearing. Patient 1 has disappeared. She's gone. So she provided a complaint, but she's no longer available. That happens. And that happens in administrative court, that happens in criminal court, that happens in civil court. Witnesses disappear. Now, if patient 1 is gone from this case, what was looking like probably a revocation case, there's a whole lot of really, strong stuff here for public safety to say, yeah, this person should be revoked. Patient 1 is gone. I might be able to prove the inaccurate treatment because there's records and show, maybe. Although she's the one that testified it was her other leg. I can't prove the sexual misconduct, sexual harassment. I might be able to prove the intoxication. So now I'm going from a revocation case to something different. And that's where a negotiated settlement's going to take place. Jason pointed out Respondent's Counsel. Respondent's Counsel is going to present a whole lot of evidence to our office once a case is filed, saying this is what the case should be. This is either it should not settle for your disciplinary guidelines are too high, because my client would like to work and is safe. This is the only time they've had a problem in their 25-year history. They can safely practice. Let's remove a couple of these conditions so they can keep on working. Jason is going to be looking at that in consultation with the dad, saying, okay, is that true? Is the public still adequately protected if we remove a couple conditions to allow this licensee to work? Because public protection is always the board's highest priority. So rehabilitation is a board priority. If you can have a licensee rehabilitate, continue to work, that is a priority. But public protection is always a higher priority than that. So can the priorities work together, and can you reach that settlement? If you've got a factual problem, well, now we've got an evidentiary problem. What is the best settlement that we can reach that protects the public's safety? And that's where those letters come from. But so when I receive that information, I then send that information to the staff analyst that's assigned the case, Carol, Marnie, Erica, or Jason. And then they look at that information and we discuss that. So we discuss that after they provide us an offer. And then we'll go back to defense counsel. We'll say, okay, you wanted 4 things, I can give you 2. And that's with them with the client telling us, the staff analyst telling us. And then we'll see. And that's where the negotiation part comes. And then if we do reach a settlement, response counsel will say, yeah, that's fine. You got us 2 out of the 4. Great, we can do that. And when I say 2 out of 4, I mean you've lowered the probation term from 5 years to 4 years. You removed the requirement that there be another physical therapist present at all times. And maybe now it's only part-time that another physical therapist is there. Maybe you've removed the, I can't supervise aides, but I can supervise physical therapist assistants because they're a licensee, an independent licensee. Whatever it may be. If you've removed a couple of those, maybe that does reach a settlement. And then that's when we provide that settlement to the board, and that occurs before the mandatory settlement conference. So we have a pre-hearing conference and a mandatory settlement conference set on our cases. So we have a hearing date. Hearing date's off, let's say 4 months, 5 months. Mandatory settlement conference and working back from that hearing date is going to be 6 weeks before the hearing. So 6 weeks, you have a mandatory settlement conference on a calendar. Respondents' counsel is working to provide their information, their evidence. Maybe your patient has credibility issues. They want to make you aware of those. They're presenting that evidence to you before that mandatory settlement conference. We're having those conversations regarding settlement before the mandatory settlement conference. From a efficiency standpoint, it's sometimes better to try to settle the case before the mandatory settlement conference, but that doesn't always occur. Sometimes parties have exchanged ideas on numbers, what would be a good settlement. You go to the mandatory settlement conference, there's an administrative law judge who's there and present and will help facilitate that process. So I think that maybe explains a little bit more about how that process and that interplay kind of works.
Thank you. And ultimately, it's proposed to you, together with the letter that Doug Gatchett described, that tries to set out what your staff member and our office saw in the case, what discovery was produced, what credibility issues exist, what diminishments in the value of evidence have played out in the meantime from filing an accusation to now. And ultimately, it's your call. And you can non-adopt, you can bring our deputies in to be able to explain some more information that perhaps was not in the letter that is pertinent for you to reach your vote. And ultimately, it's always your call, both when it's a proposed stipulated settlement or a proposed order after hearing. So yes, and then working within the confines of your disciplinary guidelines, which are excellent, and your laws and regs, which are as well.
And so going back to the disciplinary process, this is that second to bottom bullet point, board review of all final decisions. So stipulations or hearings are final decisions. The board has to provide that final review to either adopt or reject that decision. So a proposed decision from an administrative law judge or the proposed stipulation, those are only proposals to you. They are not the final. The final comes from the board. The board is vested with that final authority. All right, so I've kind of put up here the players in the disciplinary process. And so this is where we kind of separate or skew out some of that in terms of explaining the executive versus judicial function. The executive officer is always the complainant. So Jason is always the complainant in every single one of our cases. The Attorney General's office carries out the wishes of the complainant. So we represent Jason. We also represent the board, but it's really through Jason. The respondent is a licensee. They're the opposing party. So if I'm legal counsel for Jason, Jason is opposing the respondent, respondent has the license. Respondent's attorney is my, basically mirror. I'm representing Jason's interests, respondent's attorney is representing the licensee's interests. The judiciary in the administrative process consists of the administrative law judge, who is hearing the case, ensures that due process is met, fairness is met, and writes a proposed decision. And this goes back to what Gloria was talking about. Even though a decision is issued by an administrative law judge, it is just a proposed decision. They are not the final arbiters of an administrative case. That's you, the board members. And that's where, quote, you're part of that judicial process. When we conclude a disciplinary case, you're now in that executive, but you're moving to a quasi-judiciary role. So we're not going to communicate with you as DAGs. We're going to be communicating with Jason about this is a good settlement, this is why we feel it is, or this was a good hearing, or this was a good case, or this proposed decision set forth the facts or did not set forth the facts correctly, and why not to Jason why we think that is. We're not going to be telling you that in that role. Once a case is ended, as a final contested case, at that point it's going to you, we're going to be walled off from you. DCA legal counsel. Your counsel is your legal advisor, always your legal advisor. And we're going to talk a little bit later in another slide, but DCA legal counsel is always part of that judicial process. They're part of explaining, yep, this fits your disciplinary guidelines, yep, this proposed decision from the ALJ adequately sets forth the facts in law, and they're going to be advising you on that. And then the judiciary process doesn't end with you. The board adopts a proposed decision, the board adopts a stipulation, makes it a decision in order. The Superior Court is always potentially above you as a final review. The Superior Court has the ability on mandamus writ to review your decision, and there are, we could spend days talking about mandamus process, so I don't really, brief overview here. Like anything, if the litigant does not like what one side has done or what the arbiter has issued, a litigant in our country has due process rights. They can always seek a higher level of review. That's what the Superior Court as judge is doing. Now, Superior Court judge review on mandamus is limited. There are some presumptions here that the board's decision is correct. When a Superior Court judge gets that, they actually have to start from that presumption that it's correct. However, like any presumption, that can be overturned with evidence in the record, and so we'd pull the administrative record and we'd have litigation over that. So that's kind of the different players in these processes. All right, the board is a judge. This is where, when you are part as a decision maker, you're not participating in the negotiation process, the investigation, the hearing process, because at some point you might actually have to sit reviewing a proposed decision, and you don't want to be seen in that underlying process, which is being carried out by the Department of Consumer Affairs investigators, which is being carried out by Jason and his staff, which is being carried out by my office. You don't want to be seen as having a thumb on the scale one way or another. That's why when a proposed decision comes to you, it's coming to you basically without you having knowledge, so you can give, as an arbiter, an independent and fair review of that. And so I always put up there the statute of justice is blind. That way, that legal blindness allows you to make a fair decision. You're not going to have ex parte communications with me. Is there a proper forum for the board to contact a DAG? Gloria hinted on it. Stipulated settlements, yes. If we have a stipulated settlement where we've made a proposal and we've sent the letter to Jason that sets forth, and the board has questions about that, then at that point you're not reviewing a proposed decision, you're not reviewing an ALJ's decision, you're reviewing a stipulated settlement. We can appear as DAGs that entered into that with Jason and explain why we believe that's a good stipulated settlement, but we've not gone through the contested legal process that is a hearing. If we've gone through a hearing, then no, we cannot do that under the APA. Yes?
The Justice's blind side, that's also where we as board members have a responsibility to recuse ourselves if we have any knowledge.
Sure, yes, exactly. If you were a partner with the litigant, the licensee, yeah, your staff counsel would probably inform you that on this case you're going to have to withdraw. You unfortunately have too much knowledge of the case, and you would be biased. You would not be an impartial person. All right, so this is where we get to that slide of DAG and DCA Staff Counsel. I think it would probably be the best way to explain this is for legal representation. Staff Counsel is always your legal representation. They will always be there to provide you advice on, disciplinary guidelines, the law, open meetings, all that information. Staff Counsel from Department of Consumer Affairs is always your legal counsel. Deputy Attorney General's Office, we're going to be less in that role. We're going to have a different role than DCA Staff Counsel. DCA Staff Counsel is here to provide your legal consultation, draft memos, provide you analysis. Our role is to be litigators, and so we're going to be there to represent you if you're sued. We're going to be there to represent you if a subpoena is issued on you. We're going to be there to represent the board in those kinds of areas. But in the discipline arena, we're going to be kind of separate from the board. We're going to be representing Jason. Jason works for you, but he's the complainant on disciplinary cases. And so at that point, we're the prosecutor. We're going to represent the appeal, the writ, and we'll be representing the board if a case is appealed or if it goes through a writ. But we're really representing Jason through that process, and then Jason is representing the authority that of the board to actually carry out disciplinary matters. All right, that's the presentation. It was an hour and 13 minutes. I'm here. I can answer any questions. We had some great questions during the presentation. I don't know if there's anything else. This is a nuts and bolts overview. Obviously, it's this is a 25,000-foot view of the disciplinary process. Hopefully, it gave kind of an idea of how this all works. But you may have questions later. We can always do that offline as well. They can go through Jason. Gloria's available. I'm available. We have a number of SDAGs. We have a number of DAGs. So we have a wealth of legal experience. I don't know, how many DAGs are we at, Gloria, in the state? 70. So we have 70 attorneys up and down the state that handle your cases. So, and like I said, we're actually a pretty select group. Licensing's probably 3 times the size of us.
Yes.
So the licensing division, which handles other regulatory agencies, much bigger. So that's great that you have a small select group, but you have 70 attorneys that do your cases. So I really appreciate the time. And I want to thank you all for giving me the time to speak to you today and give you a presentation, and thank Jason and his staff for making this possible. So thank you very much.
Any board questions, comments? Probably one of the best presentations we've had in a long time. So we really appreciate you taking the time and explaining all of this, even though some of us have been on the board for some time. I think we've had some light bulbs go off this morning. So very much appreciated. And although we don't know the details of the cases that you and Jason worked through, we do know that you have a strong working relationship, both with you, John, and with you, Gloria, and we're very grateful for that. He speaks highly of both of you, and we appreciate what you do for the board.
It's a real privilege and honor to represent you every day across the state and to have your trust. We are very, very fair and always looking out for your best interests. We may not always agree with what Jason and how a judge sees it, but we're here to try to strike the right balance every time between rehabilitation and public safety as well. So thank you very much. And our door is always open to come back. I know Gatchett is coming back at some point in the future to help with expert training. And so our door is always open. And just honestly, thank you so much for the invitation. We're so happy to be here.
Glad to have you. And I want to ask if there's any public comment, if there's anyone who has questions, if there's something that you want to know, please feel free to come up and ask. And if not, that is okay. And so I think it's probably, yeah. Oh yeah, Gloria.
I just wanted to acknowledge the fantastic relationship we had with Elsa Ibarra. I must say that that's one of the things that I hate about state service is seeing really great people go. She leaves behind big shoes to fill. We're really looking forward to working with Erica Calderon. And we look forward to developing that relationship with her further, and we hope that she stays here a long time. So I just wanted to acknowledge that the work is not easy. We're all public servants. We're here to serve. And having Elsa on board is just really, really nice for me, especially as a new deputy. I've known her since I've been here, since 2005. And one of the first people that welcomed me as senior assistant 9 years ago, and I was picked by Kamala Harris, was Elsa Ibarra. And being a fellow person of color and having her in the client agency was just an amazing welcome for me on a personal level. So I'm getting choked up. I will step away, but I wanted to say thank you very much to Elsa, who I know was smart and is not here because you know, she'd be probably a little teary-eyed too. So we wish her the best, and again, we also wish Erica the best as well as she starts her journey here, working for you and Jason. Thank you.
Thank you. Thank you for it. Thank you for mentioning Elsa and honoring her today. We did a little of that yesterday, and it's nice that you brought it up again because it's well-deserved. So thanks for that. As far as agenda items go, yeah, Tom?
I just wanted to speak on that presentation. I wanted to speak on the presentation. Thank you so much for that. I mean, I've been confident in my understanding and my decisions, but today you made me even stronger, my confidence even stronger in the work that I know I personally have been doing, and I'm gonna go as far as to say maybe other folks on this board as well. So thank you for that.
Well, thank you very much. And just to, you know, what Gloria said, Jason is a fantastic leader of this, for you. He does a wonderful job of speaking very clearly what the board's voice is to us, and he's always willing to take our calls. And so I've found that Jason has been a great leader, and yeah, we're going to miss Elsa. She was fantastic. We look forward to working with Erica. Worked with Erica before with the medical board, so I think she'll fit great in that role. And all of your staff analysts are fantastic. So I just this is a really great client, and I don't think anybody says anything bad about working with this client. I've never heard anything. Of course, I'm the liaison, so I'd probably yell at him.
Thank you so much. Okay, 10:20, is it a good time for?
I think it is. No, I would just, you know, on behalf of the board, to the Attorney General's office, thank you for making yourselves available for this kind of thing. I think it's a notch in the belt for board members and their training. I think it's something that is just a little bit above board member orientation training that you receive with the department, but a peek behind the curtain and a look at the intent of, you know, how things work and why they work, and realizing that there is a beauty in the justice system at the administrative level that is an example to be echoed. So, you know, thank you for being here.
Okay, it's 10:20, so let's take a 15-minute break and come back at 10:35. Thank you. We're back on record. It's 10:35, right on time. We did good this time. And we're going to pick up with agenda item 24, administrative services update. Thank you.
Hello. My name is Liz Constancia. I'm with the Administrative Services Unit with the Physical Therapy Board, and I'll be reporting on the budget today. So if you can turn to page, if it's okay, we can start at page 74.
Okay, just a moment.
Okay.
Can everyone hear her? Everyone hear her fine? And Bryce, can you hear her as well?
She said I could take this off.
Yeah, for while you're doing your
While presenting.
presentation, so that the video, people watching will be able to see your face as well.
Or read my lips. Yeah, I'm just kidding.
There are people who
Yeah.
need that.
I know. So if it's okay, we could start at page 74? Or did the board members need time to go over the briefing paper? Okay. First, I want to thank the DCA Budget Office, Sarah Hinkle, for always providing that support to the board. We really appreciate her. And also Kenneth Mice. I know there's a lot of work that goes into that, to this report and getting the numbers, and so I really appreciate everything that he has done. The governor's authorized budget for the Physical Therapy Board is $6,637,000. we had a total expenditure for fiscal year, 21-22, $6,397,992,000, which was 96% of our total budget. So it's pretty good. We had a reversion of $239,008. I need my script. The budget office has confirmed that we did get reimbursed for the $94,000 for the contract tracing loan that was loaned out, so we did confirm that. It went back into the fund. Did anybody have any questions on the expenditure report?
Just a comment, Jason, you also referenced that almost 240,000 reversion to the budget yesterday, and I think that was a little bit of a surprise because at the last meeting we were thinking, it was going to be close, and you did touch on that yesterday.
Yeah, and so, and Liz kind of referenced, so Sarah Hinkle works for the DCA Budget Office and kind of, assists the board in crafting its budget along with the governor's office. So just kind of a little bit of background, especially for new members, is that we have a fund, and in that fund, we collect all of the revenues from application fees and renewal fees. Every year, the governor's office provides in their legislation what we are going to be able to spend, and we also categorize those monies into these line items that you see here. This year, because we were still kind of just coming out of a pandemic, because we're talking about essentially fiscal year that ended last July, right? So we're just now reconciling the books. We're bringing these numbers to you as part of that fiscal year closeout. The beginning of last fiscal year, we were still fairly well in depth when it came to pandemic and preparation for things like telework. And so the very first 2 quarters, we were investing in making this board as agile and as mobile as possible with the idea of telework. And so we had equipment purchases, improvements to space, a new telephone system, those kind of things that were done because they needed to be done. They were antiquated and we were kind of advancing technology, but we also strategically did them to make ourselves a little bit more adaptable for things like telework in the event that, we ever have another global pandemic or something like that. And so those first 2 quarters, we spent some money. And the budget office looked at that and gave us this kind of dire warning that if you continue to spend those monies over the next 2 quarters, you're going to become very close to expending your whole budget and maybe even going over. And so they use a very conservative projection system. I brought that to you just out of due diligence, but I think if you remember, we also provided that cautionary, but we also said we also think that these are very conservative projections. We don't have any intention of spending that same kind of money in quarter 3 and quarter 4 that we did in quarter 1 and 2, so we think we're going to be fine. Turns out we were more than fine. Almost $250,000 back into the budget. And all that does is when we talk about our fund and how many months of reserve we have, what we're saying is, should we stop receiving revenues of all kind, how much monies do we have in the PTBC fund to continue operations? And that projection is usually, right now it's about 10 months. When we project out, when we look out in fiscal month condition, you'll see those numbers start to diminish. But, just as a point of education for members, I always want to kind of highlight, we're very good at projecting what our expenditures are going to be, right? We can look in our past and we can see that our expenditures typically increase anywhere from 3 to 6% for reasons of inflation and economy and salaries being increased based on merit performances, negotiations through unions, those kind of things. And so we know what those projections look like. For revenue, it's a little different. We internally can anticipate we're going to have an increase in the applications, we're going to have an increase in the licensing population, and that will generate more revenue. But I can't guarantee those things. So as a conservative measure, we use what we call straight line measuring for revenues received. What did we get this year? We know we're going to get it again next year. We don't know that we're going to get any increases, so we just straight line out. And that's why one of the reasons why you see that fund condition start to dissipate month after month. It's not to say that it's not accurate, right? We should always plan for a rainy day, and so those conservative measures help us with that. I find a little bit of relief knowing that the licensing population is growing, and we will have an increase in revenues as a result of new renewals every year and applications received. But it's always something to keep in mind when we look at that fund condition.
Thank you. Any questions or comments for Jason? Liz, are you going to be going through the reports?
Yes, we can go to page 75, and right here is a breakdown by quarter, and then you can actually see the differences, so the increases and decreases. In comparison to last fiscal year, you'll see here by each quarter and then year to date. So there was a difference. We had an increase. It wasn't significant. It was approximately 21%. And again, this is natural. We usually increase every fiscal year for expenditures as we continue to grow and things that come up, and it could be in any of those areas. For example, personnel, you can almost bet that it's going to be at least 2% every fiscal year because there's things that we have to account for, changes in whether it's health benefit increases, anything like SCIF, workers' comp insurance, so things like that. So it wasn't significant. It's nothing to be alarmed about.
What's SCIF?
That's part of workers' comp, and so usually there are differences. So when things, for example, when our rates increase for health benefits, obviously the budget office goes in, and when they build a budget, they give us those increases without us going through that budget change proposal process. So we get those adjustments made for us. And so they do account for that, so that's nice.
Yeah.
Was there any questions on the chart? No? So moving on to page 76. So what you have in front of you is a 3-year milestone. So here we had, if you're looking from fiscal year 1920 to 21-22, the board total revenues increased by, well, probably 3%. There was a 3% increase. Again, not a significant increase over the 3 fiscal years.
Which chart are you looking at, Liz?
I'm looking at page 76, and it's the 3-year milestone for expenditures. So you look at for 1920, we had expenditures $5,248,579,000, and then you look at for fiscal year 21-22, we were at the $6,397,992,000.
Looks like
So-
you did a great job on overtime. It's at 0. That's a great job on that.
Yeah, we typically try to avoid overtime just with appropriate staffing. And so one of the ways that we do that, though, just in transparency, is the use of limited term positions. So if we have a potential, maybe an increase in trend work that needs to be addressed instead of utilizing overtime, we will actually bring in a whole nother body through a limited term position. And that limited term position will use a 1-year or 2-year term for that person to kind of measure the labor that's involved, determine whether that really was trend or is it just constant workload that we can expect moving forward. If it is constant workload that we can expect moving forward, we'll just do what we can to move that limited term position to a full position. We'll use that kind of period of time to justify it. If we deem that it was just trend, it was an increase in workload, and that workload has now diminished and dissipated and it's no longer there, the limited term allows us to let that person return back to the pool.
Great. That's super smart from a private sector. That's an incredible number, so keep it up.
Okay.
Yeah,
So you,
Liz, for the, I'm sorry to interrupt you, for the personnel services, last year it looks like we jumped for civil services permanent, like over 325,000. And is that like a combination of added positions and salaries, as well as merit increases, as well as the benefits? All
It
that's
is
included-
a combination thereof. And so anytime you see the addition of what we call position authority or PY authority in the reports, and you'll hear me talk about those as a result of successful BCPs in the past, when we received an SSM1 over the applications and licensing unit, additional SSA analysts within a certain unit, those kind of things, they'll show themselves here.
Do you know off the top of your head how many positions that included for that fiscal year, 21, 22?
I think we had two
New
positions, this 21, 22 over 21, over 19, 20.
Two additional positions.
Two additional positions.
Thank you.
So yeah, this is a really good breakdown. And if you look at just over the span of 3 years, there was like, it was a 22% increase. So. Any other questions?
On that page, in the gray box toward the bottom, enforcement totals, that very last column, would that be 1,905,274? There's a comma after the one?
Yes, it would be.
Yes.
Okay, thank you.
Liz, I have a question.
Sure.
Looks like pro rata is going down significantly. Can you explain why? It's sort of half of where it was.
Is there a certain line item?
Under, I guess, department, yeah. Well, no, I think it's pro rata is underneath that.
Was it for Office of
OIS?
Information Services?
OIS pro rata, kind of in the middle of the page.
Yeah, and that just goes with the pro rata. It could be up and down. It depends on I would say, the volume of services. So it's not we don't
Okay.
get charged like a flat rate, right? Is that what?
Yeah. Some members have had the benefit of having that display of services from DCA about pro rata services, how each individual service is calculated differently. Some things are invoiceable, some things are based on the number of licensees we have, some things are based on the number of transactions we do. Here, I think the most significant decrease for departmental services is OIS, right? It's significant. And really it comes down to that capital investment that we had done initially in Breeze. Now that Breeze is up and running, we have less expenditures as it pertains to the maintenance of Breeze. The more changes that we do in Breeze, obviously those costs are going to be reflected here. Now we're down to just kind of this point where we're kind of fine tuning it, right? Some of they're not drastic changes. We're not adding new license types. We're not making significant changes as a result of legislation. And so those costs distributed amongst all of the Breeze clients are less. And we're seeing that benefit here 3 fiscal years down the road. We knew 3 years ago that our pro rata investment into Breeze was going to be very costly, but we anticipated that it would provide a benefit, and we're seeing that now.
Okay, thank you.
And so that OIS pro rata, is that Breeze and only Breeze?
It's not only Breeze, right? OIS provides us service for everything when it comes to networking and setting up of our equipment and PCs and our phone systems and our personal devices and those kind of things. So it is really the overall maintenance the DCA provides to our technical side. But Breeze is a good example because it's a very substantive portion of that cost, right? Breeze and the maintenance of Breeze is costly compared to things like networking. The addition of a few PCs because we got 2 positions is nominal, but the maintenance of Breeze and the volume that goes through it, not just for us at Physical Therapy Board, but for all of the clients that utilize that project, is distributed evenly amongst us based on the volume of services we push through it. There are other boards that aren't on Breeze. We call those the legacy boards or some of the business modifications that are going through now with new products other than Breeze. And in pro rata, those calculations are made where those costs are distributed amongst those groups that are what we would call business mod, or for those not on Breeze, they only pay for what they use in the old legacy systems. And so when we look at those costs here, part of that pro rata calculation is we're paying for what we get. We are in kind of a pool, but we're all in the same pool, and then we're measured equally about the volume or the number of transactions that we use.
Well, I'm glad it's going down. I don't pretend to know what maintenance of Breeze costs or what it entails, but would you expect that remain relatively the same now each year?
I think we're
should
kind of at a
stabilize.
flat line position right now when it comes to maintenance. There's always that potentiality that we could have something that creates a significant change. And if that happens, then we'll have an increase in those costs. The thing that I think that's important is in those groups, those other boards that are included in Breeze, if they have a very substantial change, we don't necessarily help pay for it, right? Because it's part of that, how many transactions do you put through, how many licensees do you have involved in that system? We pay our proportionate cost for use. And so while it's not invoiceable, it's close.
And on enforcement totals, we see, you know, a 3-year trend going up, but this is something that can go up and down, and it's not really in our control.
Enforcement, you can never predict enforcement
Yeah.
because it's based on the number of complaints you receive, right? And so it's hard to say. One of the things that I would identify here, though, is kind of what I would call a rebound effect from the pandemic. We did have a lull because, I mean, basically physical therapists were restrained from providing as much health care to our consumers during the pandemic just by the nature of their art. And so we did see a reduction in the complaints received and then in those investigations as well. We're seeing now that it's steadily climbing back up, and that could be just a normal yearly trend that's kind of just a little bit further exacerbated by catching up from the pandemic itself.
And if I can add to that, part of those increases are also with the increased cost of the AG's office and OAH.
Very
So-
good point. Yeah, so reassessments of outside agencies, that being the Attorney General's office and their hourly rate for services provided, or even the Division of Investigation, and what they're determining is their hourly would reflect in this number as well.
Thank you.
Okay. So we can turn to page 77 in your agendas books. I apologize, there is not a revenues report. It was omitted by accident. So you don't have that in front of you. So I'll go ahead and just provide you with the data. The board's revenues for the fiscal year 21-22 were $6,542,779,000. In comparison to the previous year, 2021, the board received $6,358,941,000. So it was about we had $183,838,000 more revenue for this fiscal year in comparison to last fiscal year, which is about a 3% increase in revenues. So again, if you look at page 77, this shows a breakdown by the quarters. And you can see the revenues. So for example, quarters 1 through 2 have increased by an average of 5.74% over a previous fiscal year. And then the board's revenue decreased approximately 1.3% for fiscal year 21-22. And if I can also add a correction to previous year 2021, that year-to-date number should be $6,358,941,000.
Any increase in any quarter, would that be attributed to new programs opening and new applicants coming on board, applying for licenses?
For revenues, certainly. I would just keep in mind that when you talk about revenues, and you kind of refer back to that pie chart of what our revenues entail, about 75% of the revenues we receive are based on licensing renewals. So the most significant increase in revenue would reside in that 75%. So new programs could have a bump. But the other part is there's really no rhyme Thank you, Bryce. We send a renewal out for a licensee 90 days in advance. If they're proactive and they choose to renew right away, we receive it in that quarter. If they choose to do it 3 months later, it could be the next quarter or even the quarter after that. And so it fluctuates over time. And I've tried and anticipate what those revenues are going to show. And I think there's just a lot of environmental factors and things like the global pandemic that affect when people renewed, and you'll see that kind of vary from month to month. We have a basic chart that essentially, because our renewals are based on the birth year and then your birth month, and they expire at the end of that month, there is some statistical data that we try to rely on that more people are born in certain months than others, but it doesn't quite line up, and I think it's deviated by that 90 days in advance. I mean, once they're given that opportunity to renew and we open that renewal up, it's a free game from there.
Okay. And then if we can disregard page number 78 from your material, going on to page 79, which is the 3-year milestone. And right here, you can really see the breakdown. So the differences, you'll see the increases or decreases for application licensing, the renewals. I really like this chart because it shows you in detail. So overall, the revenues increased by 3.48% from fiscal year 1920 to this fiscal year 21-22.
And this is where I would just kind of remind those revenue projections where we flatlined in our projections for our fund condition, but you can see here in the actuals from the last 3 fiscal years, regardless of the pandemic even, the revenues increased from one year to the next.
And you can see here that the renewals are the highest generating revenue here.
Quick question, sorry. So the ENMG, KEMG, when's the last time we received an application?
Ooh.
It's been a while.
I want to say 2018. Yeah, okay. Since 2018. And I believe in that fiscal year we received 2 applications. Just one. Just one.
Any other questions? No? Okay.
Thank you to
So
Ken, and thank you for your work, Liz.
Oh, you're
This is
welcome.
helpful to see.
So with the projections and the workload and revenue data collection, the board anticipates a fund condition of 2.0 in budget year 24-25.
What does that mean?
That means that's a 2-month reserve
In 2025?
in 24-25. And so that's just projections, but I need to make sure that I let you know because this is the end of year reporting. And so right now for 21-22, we were at 8.6. And then 22-23, we moved to 6.6. And you can see the trickle down effect. I wouldn't be too alarmed right now, only because I know that we're very conservative with the money. We have reversions going back into the fund. I would really be concerned when we were if we were spending more than the revenues being received. And then you'll see that really significant trickle-down effect where you're going to be facing insolvency. So I don't see that. Yes, we are going down. But again, these are just projections, and workload and revenues vary throughout the year with the new schools opening, new applications coming in and things like that, and revenues will be increasing. This will change.
Yeah, but that is a good red flag way to approach it. When you actually, as members, see our expenditures outweigh our revenues received in the actual number. So when we reconcile at the end of the year, if we've actually spent more money than we received for that fiscal year, that's a good red flag to start really looking at it. when we talk about the fund condition and right now having 10 months in reserve, and based on very conservative projections, next fiscal year it coming down to 7 months, and then the following fiscal year it coming down to 4, and then the fiscal year after that coming down to 2. Again, that's using that very conservative revenue projection model where we don't show an increase in our revenues, but we know from what we can see that we are going to have increases in revenue. But the good red flag is if you see us living beyond our means, if we're spending more money than we actually take in a given fiscal year, that's when we really start paying attention to the fund condition.
I've got two silly questions. For DOD, fiscal is October to October. What is our fiscal? Is it the same? Or
July 1.
So it's July to July,
Yeah.
tracking. July to June. And then what's the definition of insolvency? Do we need 2 months rainy day fund, 3 months?
Great
What is
question.
the definition?
Yeah, great question. So some members on this board have recollection of the threat of insolvency. Anything under 3 months in revenue is when a board should start to anticipate and consider the idea of a fee increase. We, at one point, based on some general fund loaned issues and those kind of things where this board actually loaned the general fund monies for other fiscal and economic reasons, we got down to a 3-week fund condition, right, which causes some of us to lose some sleep at night. And we proposed a fee increase, and the fee increase was substantive enough to alleviate any of our fiscal issues, and that was recent enough that I don't see a reason to increase fees anytime soon. But like in our sunset conversations, we did ask the legislature to consider extending our statutory caps, the authority in which we have fee increases, because you never know what's going to happen. You could have unforeseen litigation. You could have another global pandemic that results in some kind of loss in revenue. And so we were just looking for an increase in the cap itself. Converse to the 3 months is if you have a fund condition that exceeds 24 months, you should consider a fee reduction, right? And my point of comfort as the administrator for me is I would like to see a double-digit fund condition, right? The minimum for me is 10 months. I really want to be able to anticipate issues moving forward, and I think 10 months gives us that ability to be flexible and to move. More than a year would probably be ideal, right? 12, 13 months in a fund condition is ideal. But again, anything under 3 months, we would have to look at a fee increase. Anything over 24 months, a fee reduction. For those situations where boards have found insolvency is unavoidable, there are other options. Some boards have borrowed money from other boards' funds with an agreement and an MOU or a memorandum of understanding of how that's going to be paid back with interest and all those kind of things. So similar to our general fund loan, when it was repaid back, we did receive the interest collected when the loan was done at the time. And so we had a loan outstanding for almost 4 years. When we got close to insolvency, they realized they had to pay that back so we wouldn't have that issue. Like I said, right now, I don't foresee any reason to contemplate a fee increase or reduction at this point. We're kind of right in that middle road.
And again, this data is, it's projections, so it's very conservative. There's not things factored in. You know, our application population probably increases, I would say 3%. Licensed population increases 5% every year. And so the fund condition will change.
Thank you. Anything else, Liz?
No, that concludes my
Any other discussion
presentation.
by board members? Questions?
Any
Any
questions?
public comment? If public has any comment or questions, feel free to come up and ask.
Thank you.
The only thing I'd add to it is, in consideration of the fund condition, is the reversion for this year of that almost a quarter goes back to the fund, and so that will alter the fund conditions demonstration too.
Absolutely.
So where it might have been 10.2 reducing down to 7, it might not only reduce down to 8 because we're putting that monies back in.
Nice. Definitely good news.
Thank you, Jason.
Thank you. So just for clarity, we did skip agenda item number 23, physical therapy student question and answer form, and if they come on in, we'll pick that agenda item right back up. So we just did the budget report from agenda item number 24. Now we're on outreach.
Good morning. My name is April Beauchamp. I'm the Communication and Education Analyst within the Administrative Services Unit for the Physical Therapy Board, and I will be presenting the outreach report. So for the website in fiscal year 2021-22, the PTBC had 561,085 web hits through its website tabs, and that resulted in an 8% decrease from last fiscal year. By looking at the 3-year milestone, we can see that the website traffic has decreased by 13%. The decrease in traffic is attributed to efforts to go paperless, direct applicants and licensees towards Breeze. So we do see that continually decreasing. For Facebook in fiscal year 2021-22, 44,581 people accessed the PTBC Facebook page. This resulted in a 32% decrease in traffic from last fiscal year. By looking at the 3-year milestone, we can see that Facebook traffic has decreased in total by 53%. The reason for traffic decreasing is attributed to the trends and changes in social media platforms. I did a lot of research on the different trends and statistics amongst the various social media platforms. And what I found is that according to one in 2020 and 2021, TikTok was the most downloaded app and the most visited site on the internet. Through researching the comparisons between Facebook, Instagram, and TikTok, the data shows that the younger demographics are moving more towards TikTok and Instagram. 75% of TikTok's audiences are between the ages of 18 to 34. For Instagram, 62.2% of users are between 18 and 34. And then for Facebook, 55.4% of users are between 18 to 34. The statistics also show that more users spend more time on TikTok than any other platform. TikTok users spend an average of 52 minutes per day on TikTok, and Facebook users spend an average of 34 minutes a day on Facebook. According to Social Insider, TikTok now has the highest engagement rate, and TikTok's average engagement rate in 2021 was 5.96%. Instagram followed with 0.83%, and then Facebook was 0.13%. Looking at our platforms, as of now, we have 3.9 thousand followers on Facebook and only 14 followers on our TikTok page. However, the PTPC, we posted our first TikTok video. It's already received 45 likes. On Facebook, we posted the same video, and it's only received 5 likes. Looking further into this, we can see also that 594 people have watched our video on TikTok, whereas 473 people watched it on Facebook. We are excited to utilize TikTok as an additional platform alongside our other social media platforms as another method to reach our stakeholders and consumers. That being said, though, PTBC, we do understand that when it comes to TikTok, there is a controversy to utilize this platform for business purposes due to security and personal information vulnerabilities. However, since we are posting from a browser and not the app itself, we have avoided those issues. And with these statistics showing the rising rate of people moving to platforms such as TikTok as opposed to other social media platforms, utilizing it as another opportunity to reach our stakeholders and consumers and will help us to further meet our mandate of consumer protection. For outreach workshops and webinars during fiscal year 2021-22, the PTBC provided virtual outreach workshops to 31 PT and PTA programs. This resulted in a 24% increase compared to last fiscal year. We also provided webinars to CPTA and FSBPT as well, and we are excited to be joining CPTA at their conference this weekend. We look forward to providing more outreach workshops to more PT and PTA programs, and we're continuing to fill up our 2022-23 outreach calendar. So one of our goals in the 2018-2022 strategic plan was to provide outreach workshops to all of the PT and PTA programs that were CAPD accredited in California at that time. At that time, there were 32 programs. As of now, there are 40, including expansion campuses. And out of the 40 current programs, I'm excited to say that we have either already presented to or we already have scheduled 39 of those current programs. And we have done presentations to all of the original 32. That was our goal. Lastly, the spring 2022 progress notes are now available on the website. I've also provided members a copy as well. And the fall 2022 progress notes are set to come out end of October, beginning November. Do any members have any questions on the outreach report?
You gave us a sneak peek of the possible new website platform.
Yes, the homepage.
Can you talk about that a little bit, please?
Yes, so the homepage has been approved. That is what you guys all received. As far as the other tabs, they're still being worked on, and we're still tweaking things here and there with those. So we're hoping that the website will be out soon. It's a really long process, but it is in the works and it is coming, and we hope to have it done before the end of this fiscal year for sure.
Is the content for all of the tabs already embedded in the new site or not quite yet?
Not yet, because we're doing a whole branding change thing. So, I mean, the content will still be the same, but we're reorganizing it, updating it, things like that. So it'll just look different.
Will there be an opportunity for stakeholder feedback, licensees, applicants, consumers, any other group, for ease of use for the website? So for instance, if I was in, or any licensee was in the group, the task force group of looking at the platform on behalf of a licensee, we want to look up a law, we want to look up continuing ed, alternate pathway, being able to kind of test it out and give feedback to the board. Is that a possibility?
It is, but in a way it kind of already exists. So just the daily communications that we receive from our stakeholders and how they're able to navigate that website, we take into consideration when it comes, and I mean, when I say daily communications, if there's any frustration in the use of the website that caused somebody to send us an individualized email or reached out through a cell phone or, a call into the board, we would take that in consideration of the changes that we're going to be making here. And that's kind of what's taking a good portion of that time, is trying to reorganize the information based on the feedback that we've already received. And so the things that we've seen where, because we have these kind of professional biases, we're entrenched in this information on a day-to-day basis, we might know where to find it. We're learning to kind of cater the website to our audiences and realize that they may not be. And so just from that feedback, it's helping us in designing those tabs moving forward.
I think, I don't know if any other board member can share about this as well, but there are times when there's a question and someone says, let's look at the website, and because we aren't looking at it every day, it is difficult for us to navigate.
Yeah.
So you might not get that feedback.
We get it.
Okay.
Quite regularly, really. And so that's part of the simplification from moving from one template to another, is trying to make it more user-friendly, simplifying the number of clicks it takes to get to where somebody wants to find that particular information. That's the sole intent in the project of updating the website.
Yeah, that would be wonderful. Will the mission statement be on the first page or the home page?
Maybe. We're still trying to work that out.
At the top? There it is, yeah.
Yes, it is.
Yeah.
It is on.
Just want to confirm that the numbers that are listed under statistics are just placeholders.
Yes.
They are just placeholders.
Yes.
I was a little surprised that we had 500,000 PT members, PT
Yeah.
licensees.
So that is a mock-up, and it's a mock-up that was provided us by the website team. And so the hope for that module that you're talking about, though, is that that's real-time information, right? And so that's one of the experiments, if you will, that we're trying to work with DCA and the website team to take a system like Breeze and have Breeze feed an HTML component on our website. So those numbers would be refreshed every night.
So, April, I said this yesterday, I'm going to say it again today. I, for one, really enjoyed the TikTok presentation that you guys put together. And I know yesterday we asked, could that be presented for those folks in the audience or even on this board who didn't have an opportunity to see it? Is that possible today, or is it not?
We might be able to pull that off. Given a break, we might bring the screens back down, and we can certainly try to attempt that.
And then one more question. In one of our past meetings, correct me if I'm wrong, we had some conversation about Breeze, it being updated or revised, or did I dream that? I don't dream about Breeze. I really don't.
So for those at home, Breeze is our applications and licensing online service system. Its sole intent is to kind of organize the application process for applicants, the licensure process for licensees, but also provide an avenue of communication for consumers as well. Breeze was an off-the-shelf product that's commonly referred to as Versa Online nationwide, and a lot of states use it. But it was tailored so much in California that Breeze really is its own system now. And while Versa Online has evolved and has had updates applied to it, because of all the changes that we've made to Breeze, those Versa Online updates can't be applied to it. And so we're taking piecemeal some of that functionality that might occur in a more generalized update to Versa Online. So if you think about like maybe your cell phones, right, Android or iOS. iOS recently had a huge update to iOS 16, and with it comes all this new functionality. But we've changed our phones so much that we can't get the general update to get the new functionality. We tailored it, maybe even in advance. Some of those things that are in the new functionality we already created in the old system with Breeze. There is a middle island, almost like a translator for consumers, that's called search.dca.gov, right? And so when you go to the board's website and you click verify a license, what some people might think takes you to Breeze actually takes you to kind of this middleman, if you will, that translates the information, so you don't necessarily have to go straight to Breeze. And it's much quicker, it's much thorough. We kind of referenced it yesterday, if you're looking for someone, you can search them by license number or name, by board specifically, by geographic location, those kind of things. And when you bring up that particular person, it would show their licensure history and any kind of enforcement issues they may have, their license is in good standing, when it expires, whether they're in current active, inactive, delinquent, canceled, retired statuses. Those would all show up in that area as well. And so we hope to keep leveraging that. And you know, this board's always going to look into the future to try to determine what's best to help us meet our operational mandates of consumer protection. And if that means, you know, how we transferred from the legacy systems to Breeze, that we might have to consider transferring from Breeze to something that's new and much more efficient, we'll cross that bridge when we get there. We might do that.
You guys heard that, right? Remember when we switched over to Breeze, how our technology challenges were right here. So get ready.
Yeah, certainly. There's always growing pains, you know, resistance to change across the board, but change is good, right? Change is beneficial. And you know, for people who have to learn a new system, going from the legacy systems to Breeze, while they might initially kind of show some resistance, they all have to admit that Breeze is certainly much more efficient and easier to use than the legacy systems were before. So.
Other comments or questions for April? Do we have any public comment on agenda item number 25?
Yeah.
And so now might be a good time to go back to agenda item number 23. And this agenda item is physical therapy student question and answer forum. And I'd like to just invite anyone from the public to come forward and ask the board anything that you might be curious about.
Hi, guys.
Hello.
Thank you
Yeah,
for having
please
us.
sit down.
Sure. Yeah. Mainly, I was curious. I know right now there's only out-of-state options for us PT assistants once licensed to continue our education bridging to PT doctoral programs. Is there any potential for California having a doctorate program bridge? Or is that not in your scope?
You want me to take a first stab at it? It's a little bit more complex than that. So whether a bridge program exists or not actually resides kind of at the national level with the American Physical Therapy Association and CAPTE, or the accreditor for physical therapy education. Having said that, really what it comes down to, and I think based on your question, is what the role is of the board in trying to kind of influence that or move it in that direction.
Yes.
And for me, that's something that is more kind of on the association level. So like the California Physical Therapy Association and advancing the profession could do that. Education typically is kind of ahead of regulation anyway. And so in this situation, the board would be speaking on that topic on behalf of the consumers, right? If there was a concern with, as an example, access to services, and we needed more physical therapists than PTAs, we might be able to come into the conversation in that conversation and say that bridge programs are appropriate because we have a demand issue. Right now, we don't really have that. There is a huge demand for PTAs right now. When I came to the board 10, 12 years ago, there were 3 PTA programs in the state of California. 3. And there's 10 times that now. Yeah. And so the demand obviously is higher. So where the board kind of falls in that conversation, and I'll let Dr. Amen Dr. Amen comment on that as well. It really comes down to, we would be there in the conversation to represent the consumer. The CPTA and the American Physical Therapy Association might have something to say about bridge programs and advancement of the profession itself.
There are bridge programs that exist. And it's up to the educational institutions where they exist, that they've established them, that they maintain accreditation through CAPTE to be able to continue those programs. Those are accredited programs. So if you were to go out of state to want to apply to one of those programs and get into one of those programs and graduate, you would graduate with a degree from an accredited program, which you could then apply for licensure here in California. As Jason said, this board doesn't have any role other than monitoring the accreditation status of the institution, and then reviewing your license, your application, that you've completed the necessary things to be able to apply for a PT position once you're there.
So just clarifying question, if we do attend out-of-state educational programs, go through their curriculum, we can return to California and practice?
You can apply for a license in California to be able to practice here, absolutely. If you graduate from an accredited program, yeah, you can submit your application as to be a PT after whatever you're doing now to help get your interest ready and prepare for your application to PT school, if that's your plan.
Yeah, thank you for the clarification, Dr. Drummer, because what I took from your question is whether there were bridge programs here in California. Nationwide, because it's an CAPTE accreditation, we would recognize any school that you graduated from as a doctorate in physical therapy, regardless of the pathway that you took there.
Good question. Thank you
Thank
for
you,
coming
guys.
forward. Anything else? Nothing from you? Okay. Any other questions for the board? What curiosities do you have while we're here It's a treat for us to be with students, so
I
we
feel like
welcome
there's
you.
some voluntolding happening over here.
Before Dr. Bachman has to grab you and haul you up to the chair.
How do I prepare to get my license?
It's a great question. I mean, right off the top.
Sarah Ford.
Start with graduating from school. Successfully graduating from school. Start with that. But there's also a process that will help you get ready for it.
I have a few subject matter experts in the audience, and so I'm just kind of glancing at them to see if they'd like to switch seats with me really quickly. So one of the things that we could do to help you prepare for that is provide an outreach presentation on the application process itself. And Sarah Conley, who's going to be sitting in this chair while I move, will tell you more about that.
Hello, I'm Sarah Conley. I'm the manager of the Application Services Program. And we actually do present to schools on this whole process, so you can get more detailed information when your school arranges that. You work with April. She's our outreach coordinator. But in answer to your question, once you complete your program, you are going to need to register for your exams through the Federation of State Boards of Physical Therapy. They're the board's exam vendor. And so you register with them, and you're also going to work with us. You're going to prepare to apply. You have fingerprinting. You have to take a photo. And then you're also going to need verification that you've completed your program, which the schools send directly to us. You submit your application online, and then while that application is being processed, you are waiting to sit for your exams. You take your national exam. There's also a California law exam you need to take. And once all those requirements are complete, and that's when we can issue your license. That's just a general overview. But there's a lot, and there's also all of the application instructions are on our website. So if you get a chance, you can go on there, check it out. And it has all the forms required, the roadmap of what that process looks like, and a checklist. And we do recommend that as you get closer to completing your program, that you look at the board's website as well as the Federation's website to know what's expected of you going forward. So this is a great start being here, so thank you for coming today. And if you have any other questions, I'm happy to answer those as well. Thank you. Mm-hmm.
Can I just put a shameless plug in for that roadmap that she mentioned? It's a very nice visual. If you go to the board and look up the application tab, it just takes you through step 1, step 2, then this is what you do, this is what the school does, this is what FSBPT does, now it's your turn, this is what you need to do. And it's just so nice to follow that roadmap. Okay, I'm getting there. So thank you for putting that together for all of us.
Thank you.
Great. Any other questions?
From what you guys all have seen, what are like the main reasons that PTAs would lose their license?
To answer your question, I think the most discipline we see, the most common offense is DUIs. Now, they're not going to necessarily lose their license if it's their first or second DUI. We'll put them on probation and work with them, try to rehabilitate them and make sure they can enter back into the practice. But that is the most common issue that we find is the drinking and driving.
I'm not sure I could add much more to that, but to Ms. Ellaby's point, a lot of our cases go to probation, right? So the language is license revoked, but immediately stayed. In other words, this could have been considered a cause for revocation, but it is stayed, which means it is not really reversed, on hold, and then a probationary sort of an agreement is laid out. And it really, the length of that probation really depends on the severity of the infraction, let's say. Help me out, my colleagues. We have had in the last 8-9 years that I've been on the board, a few cases where we've actually had to revoke the license without putting a hold on it. And typically for pretty egregious acts like sexual misconduct, that kind of rises to the top of why you might have a license revoked. But to Ms. Ellaby's point, alcohol-involved incidents are usually the cases that come before the court, or documentation deficiencies, those kinds of things.
So take a Uber.
Yeah, be good humans and take an Uber.
I'll just add two things to it. One is I kind of want to put that into context a little bit, right? So as far as licensees under the Physical Therapy Board of California, there's a little over 40,000 of you, right? And so if you think about that number, you would think, and I just, to address that question specifically, there's this like, the big bad board is going to come take your license, right? I mean, that's great because we love the deference for the authority and the respect for the practice. But when you look at the numbers, we only receive about 500 to 600 complaints a year typically. And of those 500, which is infinitesimal when you think of the number of licensees that are actually practicing on a daily basis, right? I mean, as a group, you're all fairly well behaved. I mean, your consumers love you, and that's one of the things that we love about you also. And so the numbers of complaints that we receive are reflective in the number of actions and discipline actions that this board takes. And so if we're only getting about 500, 600 complaints a year, we're only taking disciplinary action on a percentage of those as well. And it's right about 5 to 8% of those cases, because we get complaints about everything. Some things that are real and had a detrimental effect on a consumer, and there was a negligent aspect to it, and we really want, there's a diligent investigation that comes from it. But we also get complaints that are that sometimes boil down to personality issues, or, I showed up for my PT appointment 45 minutes late, and they wouldn't reschedule me, and I want to file a complaint, right? And those are every complaint that the board receives is treated as a complaint. It's open, it's investigated, it's looked at on its merits, and then it's determined whether it's jurisdictional, if it needs continued investigation, or it can be closed. The second point for PTA specifically, some of the things that we have concerns about are supervision, right? If you're being supervised correctly, if you're acting within your own scope, or you're acting autonomously, do you have such a trust relationship with your supervising physical therapist that they're asking you to do things that are outside your scope and you shouldn't be doing? Be very cognizant of those. 9 out of 10 times if we open a complaint about a physical therapy assistant, we also open on the physical therapist supervisor, right? It's because we have to look at that relationship. It's possible that an assistant can just completely go off the rails of the direction that was provided to them by their supervisor, but we have to look at that. And in those situations, you have as much responsibility as a physical therapist assistant to follow and adhere to the Practice Act as the PT does. So it's not that you're held harmless, but we really look at both of your roles in the situation and what's the appropriate outcome.
Could I add something real quick?
Absolutely.
Mr. Kaiser? So and I think another important thing to realize is that our charge, the main thing we must abide by is protection of the public, right? So consumers of physical therapy. That's kind of at the top of the pyramid. And I would say also an important sort of subcharge, I guess, would be the probation or the disciplinary action is really not intended to punish. It's really intended to give the practitioner an opportunity to demonstrate that they've sort of taken accountability for their actions, to rehabilitate and demonstrate to the board that, I, sort of speak, learned my lesson, and I'm really moving forward and conducting myself in a professional manner. And I think that's important. It's not a punishment. It is an opportunity with some oversight to allow that individual to grow as a person and as a professional and take some accountability. So that's something that I had to kind of wrap my head around years ago and make sure that we're doing this with the intention to protect the public, number one, and number two, to provide the practitioner with opportunities to make corrections and move forward.
Thank you for that. A good way to see that in kind of a practical way is you can visit the board's website, and to April Beauchamp's presentation, we publish a newsletter. And in the newsletter, we talk about the licensees that have been disciplined since the last newsletter. And what I would encourage you to do is just kind of, look at that newsletter, see what the violations were. And if you're looking at one, and let's say you find someone that's a physical therapist assistant and that attracts your attention, you can use that verification website that I was talking about with search.dca.gov, shameless plug, and actually pull up the documents that pertain to that discipline and look into it further. And you can see what it is they did, why, how they got there. But to Dr. Dominguez's point, when you're reading that document, understand that nothing in that document as far as the disciplinary order was meant to be punitive. Everything was there with the intention of creating a protective order for the public, right? To allow that person to continue to practice, but also maintain that level of protection while they did it during that order. We're not there to, put unnecessary fines on licensees as a way to kind of stick it to them or suspend them from the profession. Even suspension, if we're doing a suspension in their order, the suspension was there for them to fulfill certain requirements, like maybe take the California law exam again, right, before they return to practice, demonstrate certain proficiencies in certain modalities before they return to that practice, or those kind of things. So even suspensions are not meant to be punitive. They're there for a specific purpose.
April, do we have additional copies of the newsletter that we can, so in the back counter, there's extra copies, so you guys can take the newsletter and then explore it, and the list of therapists and therapist assistants who had discipline in the recent past, they're at the back. They're in the back pages of the newsletter, so you can take a look at that.
Yeah, yesterday morning, we had a petition for early termination of probation, and so if you go back on our website and look at some of the prior petitions that we've held here at our board meetings, it becomes very real. We were just talking about, this is an actual person, a licensee, whose life has been changed because of decisions that were made, and but we also get to see growth, and we get to see, some real human qualities of the person sitting in front of us, and then we need to make a decision. But that makes it real. I mean, if you can watch even part of that hearing, that would be, I think, it would probably really bring to mind, at least for me, when I first became a board member, I thought, oh my goodness, 2 beers could do that to me. 2 glasses of wine can do that to me. You think, a couple drinks with a friend, there's no problem, but it can be a big problem. So that can be beneficial.
Yeah, so this meeting is being videoed, and that video will be stored on the website. So you'll be able to go to the website, find the part in the video where you're asking the questions, because you're on camera. So you can share that.
We've been storing video on a YouTube platform going back to 2011, but I think YouTube only lets us go back to 2015, if I remember correctly. So you can go back and watch board meetings, and typically the first day of a board meeting is what we call a petition day, where there is somebody that's coming back who has either had their license revoked and is petitioning for reinstatement, they want to return back to the profession, or they're an existing probationer that wants modifications modified before the end of their probation. And that's one that, for students, I think would be extremely beneficial just to kind of see that portion play out. We talked about Sarah Conley providing a presentation for applications and licensing. We also have a menu of different presentations that we can provide to programs, and one of them is just the existence for the board. And one of those things is talking about how this board regulates its licensees, why we exist, what are the differences between statutes and regulations, what's your practice act look like, where is it contained, are there other laws and regulations you have to be savvy to, because we're only one aspect of regulation when it comes to healthcare. And so, I would encourage you to go to the board's website. It's I know we're competing with HBO Max and Netflix and Hulu and Disney Plus and blah, but the YouTube channel for PTBC has some pretty dramatic entertainment too. So if you want to, take a look at a couple of those hearings, it'll give you an idea of how that plays out. It'll answer one of those questions directly, like what does a licensee really have to do to actually get their license revoked? And you'll see some of those. And like I said, they play out in a very dramatic courtroom style.
I would just like to add to the fact that the makeup of this board, not only are there practitioners on this board, but there are 2 public members on this board as well. So we're bringing the perspective from every angle. So when the decisions are made, they are made, in my opinion, fairly and justly, and we've taken into consideration every viewpoint possible before we make a decision on which way we're going to move forward.
If you can't tell, having students here at our board meeting is one of our highlights. One of the things that we really enjoy. So thank you for your good questions. And do you have any follow-up questions from anything that we said?
I do have one more question, but it's like a totally separate question. If you were to be licensed in California, but then were to move out of state, what is that kind of process? Do you have to take an exam again? Or does it depend like what state you go to, kind of thing?
There's actually a couple different factors. So you get licensed in California and you decide you want to move to Texas, right? You have choices at that point. You can keep your license in California valid just by adhering to the regulations and doing your continuing competency and paying your renewal fees. And then you're free to come back to California anytime you'd like, right? If you know you're going to be away for a significant period of time, we have different statuses that you can choose. Inactive status would prohibit you from practice in California, but it would also mean that you don't really have to keep up with your continuing competency here. When you choose to come back to California, you'd have to pay whatever the fee is to come back, and you'd have to attest that you got 30 hours of continuing competency over the last 2 years for however long you've been gone. We have a lot of dually licensed, well, multi-licensed people, travelers that in both physical therapy and physical therapist assistants. And I think the record that I have is I've actually seen somebody who's held 32 licenses simultaneously in different states. And that's a lot to maintain. It's a lot to keep track of. And so that's why we give these kind of different statuses, so you have that flexibility to move. If you left and you didn't do anything, you didn't pay us any money, you didn't follow continuing competency or anything, your license would go into a delinquent status. And delinquent sounds like a bad thing, but all it really means is late. And as long as you're not practicing California while you're in a delinquent status, no violation's been committed. You'll remain in delinquent status for about 5 years, and then your license will move to canceled. Again, dramatic, sounds horrible, right? But all that means is if you were ever to return back to California, you'd have to go through the application process again. You'd had already taken the National Physical Therapy exam at one point, and so we would make you take it again. We would make you take the jurisprudence exam or the California law examination again, because the potential is the laws could have changed since the last time you were here, right? And you'd have to pay initial application fees again. So you always have that ability to return, even if you're going to go to a different state.
Jason, could you explain how different jurisdictions in different states have requirements for dual licensure? So if she were to go to Texas, she would probably have to take their test.
Absolutely.
You know what I
So,
mean?
and that's the thing is when you're moving from state to state, each state has their own individual practice act. And in that individual practice act are different application requirements. Some states have criminal-based background checks, some don't. Some have continuing education requirements, some don't. Some require a jurisprudence exam or a law exam of some kind for that state, and some don't. All right. So when you move wherever you're going, whatever state that you might be going to, just do your research and get clarification on what their requirements are. And then once you're licensed and you are going to maybe hold this kind of dual position, or you're a traveling PT, just be really cognizant to the rules for the continuing education as you move from state to state. If you do it right, you could take one class and get credit for it in multiple states, right? So you just want to find out if that class is accredited in more than one state. And so especially for us, we're hoping that if you take a class, you want to make sure that it was accredited in California.
And just to maybe get right to the heart of, I think, what your question was, you won't have to take the physical therapy assistant licensing exam again. If you pass that, then all you have to do is submit an application to each different state where you might want to work. Awesome. And you might, as Jason said, you might have to take their law exam because their laws are going to be different than California laws. But one time taking the exam, as long as you pass it, you get the passing score, then that will allow you to be able to apply for a license in any state. You may not want to work here at all. You may be getting your degree here, and you may want to apply to go work in Nevada or in Texas if that's where you want to go. But as long as you pass the exam, then your step one is done.
So the group that's here today, I don't know, maybe by a show of hands, do you all intend to be future California licensees? Nobody's, yeah? Okay, great. When we do presentations in front of classes, depending on the school we're at, sometimes there's they might specialize in out-of-state education or that kind of thing. So some of the people we're talking to are going to other states, and so the application process that we're teaching doesn't really pertain to them because they have no intent in ever applying here.
Thank you.
You're welcome. Thank you. You're welcome. Thank you for your questions. Any others? Any other curiosities while we're here? We'd love to have you come forward.
Good morning. I'm not a student. I'm their program director. So I want to first start off by thanking you guys for coming down here. I really appreciate you coming and spending a couple days with us. I have a question, actually kind of about the makeup of the board. I had a good segue earlier. Thank you. I have always talked to other PTAs. I'm also the PTA caucus rep for California. And so I talked to other PTAs about their licensing board. And other states have PTAs sitting on their licensing board, and California does not. And I personally, I am a PTA as well, so I could have a slightly biased opinion, recognizable. But I feel like PTAs can also bring a slightly different perspective on consumer safety. So I was curious if there's talk about California ever opening up an additional space on the board for a PTA member.
It's not listed on my credentials, but I also have a PTA license before I was a PT. Nice. If that helps at all.
I think it answers some of the questions. It happens sometimes where we do have people that have experience in PTAs. Whether or not there's ever going to be a position that's open up, there's a couple things that I wouldn't say are problematic with that, but just to keep in mind is you almost always want to have an odd number of board members, right? So that's first and foremost. Second, whatever that change is, it would require a legislative change, right? And so that direction is going to have to come to us from the legislature. And that might be moved in a couple different ways. It could be moved by the association or public outcry or anything like that. So has there, to answer your question specifically about has there ever been any talks, nothing that I've seen actually rise to the legislative level. And so it has been, we've heard it as commentary and question and concern, and we're certainly aware of it, but it's nothing that we've ever seen an assembly member or a senator take action on.
I think it's a fair question. And although there might not be a physical therapist assistant seat on the board, I would like to think that this board is very open to physical therapist assistant comment. Whether it's during the meeting or outside of the meeting, we would love to hear the perspective of the physical therapist assistant on any issue.
Would there be potential? We've just completed sunset process and has gone through legislation. We're waiting for the governor's signature or inaction for our sunrise to come through again for another 4 years. So unfortunately, we don't have any authority at this point to be able to modify. But when we go through sunset process in 4 years.
4 years, 2027.
4 years, there could potentially be consideration of a proposal from the board to add a PTA to the makeup. But that would require a lot of supporting evidence, supporting information from individuals, from assistants, and we have to have a legislator sponsor our bill. So we would need that individual to be on board with sponsoring that component of it as well.
Part of the sunset process includes stakeholder feedback, right? So when we go through sunset, this as an example, we just came out of a global pandemic, and one of the changes that was stirred by that pandemic is a waiver that was given to us for direct access that required, a physician or surgeon to look at, have an in-person meeting with your patient before they'd sign off on the plan of care. It's kind of antiquated, right? We know that that's not really the case. We have telemedicine, we have other means, and it's more efficient, both for the consumer and for the practitioner. And so as part of sunset, that's one of the things that came up as a topic. And sure enough, now we have this, what was normally a waiver, now as part of law. So sunset's certainly a vehicle that you can provide commentary to in 2027. Between now and then, there are going to be 3 legislative sessions, right, where there is opportunity through the association or just through your local representatives to breach that topic too. And that's one of the things that we always encourage our licensees to be involved in, is that engagement at that both legislative and regulatory level. If you receive any kind of communications as a licensee about future legislation and you have you feel some kind of way about it, we want you to provide that to the authors of that bill and let them know. If we are proposing regulatory language like we discussed yesterday with retired status, you can kind of see, if you watch back in the YouTube video, that we received some comments about that package. We have to look at each and every one of those comments and answer to them as part of that regulatory package. And we need that because we don't have all of the great ideas. We might propose something and somebody might, point out kind of a fatal flaw that nobody else has ever seen. And that's the beauty of the regulatory practice or process, is that we really want that engagement and that stakeholder feedback.
Thank you.
Other questions, other comments?
I don't think everybody's taken their turn yet.
We're counting heads. Anything else? Any board member questions or comments?
The prior question from the director got me thinking, if we added a PTA seat, probably have to add a public member seat, right?
Yeah, either
So you
or.
have an odd number and,
Yeah.
I don't know that an odd number is necessarily required. I understand the rationale behind
Yeah,
it, but
best
the
practice.
number of times that we've been short and had quorum of an even number of voting board members is, it in my mind, it sort of makes the point moot.
Yeah.
But
Are you guys ready to see the TikTok?
If you want to take a small break, we could probably arrange that.
So we have some of the unit reports still to review.
Absolutely.
I guess the question is, with the time frame that we have to be out of here this afternoon, would we want to postpone lunch, do the TikTok video, go through the reports, and then call it a day versus taking a full lunch?
I think the postponement of lunch works nicely anyway, because I don't, I'm kind of relying on admin. What time are we? They're on the way back now. So we would potentially be taking lunch at about 12:30. And I still think, if we took lunch, and I still think there's more than enough time for us to finish out the service updates. So,
Okay, so let's take, let's do 15?
yeah, 15's fine.
15 minutes, and we'll be back on record at, if that clock is right, 12:10. 12:10. Thank you very much for your participation.
Okay, the time is 12:10. We're back from recess. And for the record, Dr. Drummer is standing on the side. I'm going to stand in the side as well. But we are going to return to agenda item number 24B, the outreach report. And would you like to say something, Mr. Kaiser?
Just to address the request from the board about the TikTok content, we're going to display it and play the video so you can see an idea of how we're kind of leveraging and capitalizing on current trends that are within TikTok. and kind of multi-purposing them for our outreach efforts. So I'll let the video play.
ATVC, where's Usher? Sorry, guys. I don't mean to interrupt. I just have a quick question. So if it's 7 o'clock on the dot, where's Usher?
Usher? Usher, is it a PTA or PTA? What school is he from? Was he a foreign applicant? I'm not sure. I didn't audit it. I can look there right now.
Okay, next. Hey, Marnie.
Hey?
Hey, if it's 7 o'clock on the dot, where's Usher?
No. Do you have a case number?
Hey, Marnie. I have a question for you. If it's 7 o'clock on the dot, where's Usher?
I don't have anyone on probation with that name. Doesn't sound good. Do you have a license number?
Hey, Erica. I have a question for you real quick.
Yeah.
If it's 7 o'clock on the dot, where's Usher?
Oh, wait, in his drop top.
So,
I guess that would have been kind of cute at the end to just put that part of the song.
yeah.
That top, drop that drop.
So it's just an example of kind of capitalizing on a trend that happened on Usher for the number of views that we can get, and just generate almost like a following, right? So the number of impressions that we get, alter the algorithm. Anybody who's ever searched for anything that relates to the words physical therapy on TikTok, this would be some of that content that helps do that. And then it compounds from there. So the number of views that we get, as kind of April alluded to in the outreach report, we have videos on Facebook that are a year old that don't have the number of impressions that this video got in the short, less than 30-day period of time. So the idea is just to capitalize on their platform, create the content here, also publish the content on both Facebook, Instagram, and Twitter, try to get the message out as much as possible, so that when we also put out really business relevant, physical therapy services relevant content, it gets viewed by some folks. And that content could be something as simple as the physical therapy is meeting today on September 22nd. Tune into our webcast with this link, right? So we get much more engagement and much more bang for our buck for our outreach efforts. So.
Kudos for your creativity and to staff for participating. Okay, so any further board discussion? Any public comment? Oh, board discussion?
I'm waiting for the TikTok with the dance moves, so put that on the roster, please.
With Jason in the front. Okay, any public comment on the TikTok video or outreach presentation?
Got a thumbs up from the crowd.
Thank you. All right, and application services update, agenda item 25.
Good afternoon. Sarah Conley. I'm the manager of the licensing program, which encompasses application services, license maintenance services, as well as continuing competency. I will start with agenda item 25, which is the applications report. In the materials provided today, in the year-to-year comparison from 2020-21 to 21-22, there was a 3% increase in applications received, which is consistent with what the budget, with Ms. Constancio, she expected from the revenue standpoint. And then we received most of those applications online. And the composition of the applications received, we have about a third of them are endorsement. So those are our licensees that already hold a license out of state and they're applying for a California license. About 2/3 of the applications are from new graduates who have not taken the exam and do not hold a license in another state. About 92% of the applications received in the last fiscal year are U.S. educated, so they're from a CAPTE accredited program located inside the U.S., and then 8% of them are educated at programs that are not CAPTE accredited, which is the Commission on Accreditation in Physical Therapy Education, and they're not located in the U.S., and so they're foreign educated. 4% are military, so those are individuals that are serving, have served, or are a spouse or domestic partner of a member of the military. And then there's also a 3-year data comparison from 2019 through 2022, which shows a slight decrease in physical therapist applications received, but it does show a 12% increase in physical therapist assistant applications received, which is consistent with the discussions that have been going on about the increase in PTA programs that have occurred. Currently, we have about 20 accredited PTA programs. 5 of those were accredited since 2019, and then we have about 7 that are seeking accreditation in the near future. So our PTA programs are growing and the applications are growing with them. We also have an increase in physical therapists and physical therapist assistance licenses issued, 11% and 8% respectively. And I think that's a reflection of some of the efforts that the board has put in place to increase efficiency in processing applications. And I'll cover 3 of those things, one of them being outreach, which has been discussed a lot today. It's really an invaluable tool to make sure that the applicants are informed of the process, which makes it easier for us to process the applications. Also, internal process updates, one of them being updating our system to better reflect our business process. I know Ms. McMillian mentioned earlier about the Breeze updates that we've discussed in the past, and that's one of the things that's helping us increase efficiency in processing applications. So we have outreach, we have internal process updates, and then also our staffing. While we do have 2 vacancies, we also have some of our newer staff. They're increasing proficiency in their knowledge and experience in the applications unit, and so that's reflected in our ability to process applications faster. And so we are seeing this in the data, and then so that's one of the ways that we measure our performance is decreased processing time. But also we are looking at feedback from the applicants. So we do survey all of our applicants, how was their experience, and we look at that. And we've had generally positive feedback from their recent experience with applications. And then also the quality of data that we have. So we are getting really good data on application processing times. Partly with the system update, we're able to see really from the time the application was received to the time the license was issued, what does that look like? And so that helps us improve our process. With that, some of the things we want to bring to you in the future are those performance measures. So I'm talking about them now. We don't have them before you, but it is a fairly new data set to present, and so we've just had that new application in place, so we're just getting that new data, so hopefully in the future we'll be able to present to you what those processing times look like, and you can see those improvements that way. We are also working on filling the vacancies that we have, so that will help us moving into the future. And then also the outreach. So we also do surveys when we do outreach with the students, and we are getting feedback that's very helpful. They are asking for more program-specific information. So for example, right now we give them guidelines on how to apply based upon when they complete their program, what exam they want to take. And we're getting feedback they really would like, what date should I apply? And so we're trying to work even more closely with the programs to get that information to help them navigate the application process. And so that's one of the things we're working on. That covers applications for right now, and I'm happy to take any questions about the materials or information I provided.
As DCE of a program, I just have to say that specialized service that you give to programs who request it to help set those deadlines and set those dates and give guidance to students is so valuable. Thank you very much for doing that.
Thank you.
Yeah.
We find it valuable as well. It's a much more, it's an enjoyable experience. The staff get to work directly with the students, and they are more familiar with some of them in doing the presentations. They get to know them, and because it's a more positive experience, it's just, like I said, it's just more enjoyable, and and really, the staff are case managers, so they're really helping and taking care of the applicants through their process. It's not, it's not broken up into, one person does this piece, another person does this piece. Once one of the analysts is assigned an applicant, they assist them through that process, and that's really our goal. We really want to get them, help them get what they need to get their license. And one thing I did not mention, I'm sorry, is we do have some staffing changes within the program. Valerie Kearney, who's with us today, but I don't believe she's in the room right now, she was just recently appointed to the lead position of the program. And so that's very exciting. We did have one departure, Paul Harrison. He was an applications analyst. He moved on to another opportunity, as well as Yura Trent, who was the old lead. And then we do have a new addition, Ariana Rathbun. She's a new applications analyst. So we have some new staffing, working on filling some vacancies. So we have a lot going on right now, but it's exciting things, and we look forward to what we're able to report in the future.
Thank you.
I have a question.
Yeah.
Out of curiosity, what does the outreach look like for people in the military or military spouses?
So that's a great question. Thank you for asking. So we are working with the Department of Consumer Affairs. It's actually a department-wide effort. And so DCA has a team dedicated to developing, to working with members of the military and have brochures and information out there, just generally. And then from that, then those applicants or licensees can connect with each individual board and find out what those processes are. A couple of the things that we've done, we've implemented the expedited licensure process. So all of those applications, the requirements are not waived, but those applications are processed faster. We also have an individual point of contact. So members of the military are not lost in general communication. They have a direct contact to the board, so they can be assisted. And so there's a lot of effort being put forth that way. And then we have a whole page dedicated on our website to how we can assist members of the military and their families.
Are there any CAPTE accredited schools on military bases?
I don't believe so, but
No, the Department of Defense does certainly defer to the same authority we do with CAPTE. So there is an equivalency application process for physical therapy assistance from their military service, but I wouldn't say it's antiquated, but I would say it's almost it's becoming unnecessary because that CAPTE accreditation is so widely accepted in the Department of Defense now.
Thank you.
mm-hmm.
Other board member discussion regarding application services? Is there anything else you wanted to go through, Sarah, for application services, or is that it?
Not for applications.
Okay.
No.
Any questions on the statistical reports at all for Sarah? And any public comment on application services? Thank you. And licensing services?
All right. For licensing services, you have the year-to-year comparison from last fiscal year to this fiscal year. We've seen an increase in duplicate requests, and that's kind of going back to the pocket license no longer being issued. We're still working on connecting with licensees, still getting a lot of calls about, I haven't gotten my pocket license, why is that? And so we explain, that change, but a lot of licensees are still requesting the wall certificate to take the place of their pocket. So still working on the outreach effort on that.
And Sarah, sorry, how much is that replacement for the wall?
It's $50 for a duplicate, yes. And then we also see an increase in name changes. Now, I don't have an explanation for this, except for maybe after the pandemic, more marriages got caught up, but we do see a little bit of increase in that. Otherwise, what we are working on is increasing efficiency in communicating with licensees that have law and regulation questions. This is an important part of our program because a lot of times this is where we have the opportunity to avoid a potential issue or violation of the Practice Act by assisting these individuals with their questions, or it can be where a complaint starts. I'm not sure that this is the right thing that should be happening, and then we'll walk them through the law and regulation, and it may go on to enforcement as a complaint. However, we do have limited resources in this area, and sometimes it can be an involved interaction with the licensees. Sometimes we cannot answer some of the questions because they might be standard of care, and it might have to go through a complaint process to determine all of the variables that are involved. So they can be, like I said, time consuming, but we are working, especially with the changes in staffing within the programs, our new lead, Valerie, and identifying how we can improve this service to our licensees.
So this is a licensee who comes to you for a licensing issue, but then says, by the way, I have these questions, or I have
No,
this
it'll
scenario?
start out just as a question.
So you're fielding it?
Yes,
Your
and so it'll
department's
be,
fielding
what are the supervision requirements? You know, can we do this? And so we'll assist them with what the law and regulation requires. Other than that, I don't have any other updates in licensing.
Board member questions or comments on the report or the statistical reports? Public comment? And continuing competency.
All right. So continuing competency is back up and running after it had some downtime as it was assisting the applications unit. But we are getting our resources back in line. There was some outreach that was done to the approval agencies, reconnecting with them. Because we had been away for a while, which was very helpful to get our records updated, as well as the approval agencies back in contact with us. And you'll see following this this discussion that there are some approval agencies that we are recommending that their accreditation or their recognition be withdrawn, and for various reasons. That's in the issue papers. Staff have also began auditing licensees effective July 1st. And so you'll see the results of those audits at the next meeting. In addition, we are working on the continuing competency regulations like discussed yesterday, and so hopefully we'll have that for you at a future meeting as well.
Are we looking to take action to remove some of these today?
So one of the things I was thinking is, and council's advice, that each individual recognition should have its own independent vote, right? So it's very hard to do one large motion for all the cities, all of them are very, very specific. But in the consideration of time, I think we go through each individual one and do kind of just a quick consensus, pass that vote, move on to the next. And Bryce is reminding me to use my microphone. So having said that, I think it would be best for us to follow along with the briefing paper. As we go over each case, Sarah and I can both give you any kind of insight or into questions that you might have about each specific one. And then I'll leave it to Madam President to look for a motion and vote.
Yes. I think board members have had an opportunity to look through these, and so if you have anything to discuss as they come up, jump in. Otherwise, we'll just go through. Somebody wants to make the motion and someone wants to second, and then we'll roll call vote, and we'll ask for public comment as well. So let's have it.
So we'll start with 27I, which is ACIC. If there's any questions.
I move to withdraw the approval agency recognition for ACIC physical therapy.
We have a motion by Ms. Ellaby and a second by Dr. Dominguez. Is there any further board discussion?
Just confirming, Sarah, they requested to have their approval authority removed.
Some of them have, and some of them were because we were unable to reach them. And
But
that's
this
indicated in this
ACIC
one. Yes.
Okay,
This
what I'm
one.
reading, yeah, just confirming that what I'm reading is accurate.
Yes, that is accurate. And one thing I just want to note before we move forward, if the recognition is withdrawn today, it doesn't prevent them from applying in the future. So like for those that we weren't able to reach after numerous attempts, if they come to us later on, they can reapply for recognition.
Any further discussion on removing ACIC physical therapy as an approval agency? Any public comment? A roll call vote?
Alicia Urban-Amen.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Next.
So on to 27II, withdrawal of the California Chiropractic Association's agency's recognition.
Move to withdraw approval agency for the CCA.
Second.
We have a motion by Dr. Drummer and a second by Ms. Ellaby. Is there any further board discussion? Any public comment? Roll call vote, please.
Alicia Urban-Amen.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Thank you.
And then for agenda item 27III, the withdrawal of California State University Sacramento's agency's recognition.
What agenda item are we on again, Jason?
27III.
Thank you so much.
Again, just to confirm that 27II refers to the agency emailing a request to withdraw.
That is correct.
Is there a motion?
Sure. Move to withdrawal approval agency recognition from California State University, Sacramento, as requested.
I'll second.
We have a motion by Dr. Dominguez and a second by Dr. Armstrong. Is there any further board discussion? Any public comment? Roll call vote, please.
Alicia Urban-Amen.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Next.
Agenda item 27IV, withdrawal of the Community Medical Center's agency's recognition.
You're going to ask again. A motion?
Move to withdraw approval agency recognition from the community medical centers.
Second.
A motion by Dr. Drummer and a second by Ms. McMillian. Any further board discussion? Any public comment? Roll call vote, please.
Alicia Urban-Amen.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Thank you.
And then on to agenda item 27V, withdrawal of Del Norte Seminars approval agency recognition.
Move to withdraw approval agency recognition.
Thank you.
Second.
Motion by Ms. McMillian and a second by Dr. Drummer. Any further board discussion? Any public comment? Roll call vote, please.
Alicia Urban-Amen.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
On to agenda item 27I, withdrawal of Atlantis Seminars Incorporated approval agency recognition.
Move to withdraw approval agency recognition.
I'll second.
We have a motion by Ms. McMillian and a second by Dr. Armstrong. Is there any further board discussion? Any public comment? Roll call vote, please.
Alicia Benayman.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez. Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Thank you.
On to agenda item 27VII, withdrawal of Medical Sciences Foundation.
I move to withdraw Medical Sciences Foundation.
Second.
We have a motion by Dr. Armstrong, a second by Ms. McMillian. Any further board discussion? Any public comment? And a roll call vote, please.
Alicia Benayman.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez. Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Thank you.
Just to pause, I will say for the record that in subsequent meetings for this kind of topic, I will not be spelling out Roman numerals anymore. I will be referring to them as sub and then the number. But for consistency's sake, agenda item 27VII, withdrawal of Net Education Design Incorporated's approval agency recognition.
Move to withdraw approval agency recognition.
Second.
A motion by Ms. McMillian and a second by Dr. Drummer. Any further board discussion? Any public comment? Roll call vote, please.
Alicia Benayman.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
For agenda item 27IX, the withdrawal of on-course learning's recognition.
Move to withdraw approval agency recognition.
Second.
Motion from Ms. McMillian and a second from Dr. Drummer. Further board discussion? Public comment? And a roll call vote, please.
Alicia Benayman.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Thank you.
Agenda item 27X, actually, withdrawal of Orange County Global Medical Center's recognition as an approval agency.
Move to withdraw approval agency recognition.
Second.
We have a motion from Ms. McMillian and a second from Dr. Drummer to remove Orange County Global Medical Center. Any further board discussion? And any public comment? And a roll call vote, please.
Alicia Benayman.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin. Tanya McMillian.
Aye.
7-0, motion carried.
Thank you.
Agenda item 27XII, withdrawal of Progressus Therapy LLC's recognition as an approval agency.
I move to withdraw Progressive Therapy LLC.
Second.
We've got a motion by Dr. Armstrong and a second by Mr. Irvin. Any further board discussion? Any public comment? Roll call vote, please.
Alicia Benayman.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
A notation for a correction for the materials. There is a second agenda item 27XII, which should be XIII. Withdrawal of UE seminars approval agency recognition.
Move to remove approval agency recognition from UE seminars.
Second.
We have a motion from Dr. Drummer and a second from Mr. Irvin. Any further board discussion? Any public comment? A roll call vote, please.
Alicia Benayman.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
7-0, motion carried.
Thank you.
I feel like this was scripted, but a correction to the materials for agenda item 27XII, which now should be XIV. Withdrawal Video Continuing Education LLC's recognition as an approval agency.
Move to remove recognition.
Second.
Motion.
Approval agency recognition. There we go.
Thank you.
Second.
Motion by Ms. McMillian, second by Dr. Drummer. Further board discussion? Any public comment? Roll call vote, please.
Alicia Benjamin,
Aye.
Dale Armstrong,
Aye.
Jesus Dominguez, Daniel Drummer,
Aye.
Katarina Ellaby,
Aye.
Jonathan Irvin,
Aye.
Tanya McMillian,
Aye.
7-0, motion carried.
Thank you. And thank you, Sarah and staff, for cleaning this up. This is a lot of calling, waiting, emailing, and answers and no answers, and so I know it's tedious work, but I think it's important. So I suppose you'll continue to identify some that have been somewhat inactive and contact them along the way?
Yeah, I mean, it's going to be a process ongoing every so often, but hopefully now that now that we're getting reestablished with the program and have the resources we need, that we'll continue that communication. So if anybody wants to discontinue being an approval agency, they'll let us know, and then we'll have so many at one time, we'll be able to deal with those as they arise.
Yeah.
How many approval agencies do we have on record at this point?
I believe we have around 130.
Good number.
Minus 14?
Yes.
XIV?
Aye.
Okay, any further board comments or questions for Sarah? And any public comment? Thank you so much.
Thank you.
Yes. Agenda item number 28, Consumer Protection Services.
Good afternoon, Madam Board President and members of the board. First and foremost, it has been a true pleasure to meet you all in person at this, my very first PTBC board meeting. My name is Erica Calderon, and I am your new Consumer Protection Services Program Manager. Just a little bit about myself. I actually started my professional career as a compliance monitor for the Maximus Drug and Alcohol Recovery Monitoring Program. Prior to starting my state career, I have worked with the Veterinary Medical Board and most recently with the Medical Board of California. I am here today to provide you with the next two agenda items. Agenda item number 28, which is a yearly update of our CPS program and its statistics for fiscal year 2021-2022, and agenda item number 29, which is an update of our probation program. I will start with agenda item number 28, stop for board member comments, and then proceed with agenda item number 29. Before I provide you with my updates, I would like to take this time to publicly thank Mr. Jason Kaiser and Ms. Elsa Ibarra for all of you for trusting me with the management of the CPS program. In addition, I would like to thank my staff for being extremely supportive during this transitional phase, and take a moment to personally tell you that I have not seen a more dedicated and more knowledgeable group of enforcement analysts like those here at PTBC. Moving on to my CPS update. For the fiscal year 2021-2022, this past year has been extremely successful and productive for CPS. In terms of staffing, in addition to my recruitment, CPS has onboarded a new in-house consultant, Dr. Alexandra Jones, to assist with our cursory review of cases involving patient care. She will be available to staff via email, by phone, and eventually we hope to have her in person in the office at least once a month for a few hours to have that direct in-person staff interaction.
In terms of our consumer complaint, we recently updated our consumer complaint form, which is now available on our webpage, making it easier to read, fill out, and gather upfront investigative documents. Instructions were added to our front page of our complaint form to our consumers to attach any copy of any supporting documents they may have in their possession, such as patient records, photographs, audio, video recordings, correspondence such as letters, emails, text messages, billing statements, proof of payments, police report, court documents, or any internal employment administrative investigations. In addition, we added our authorization for release of patient health information form to our complaint. By doing all of this, CPS staff hopes to save intake processing time, allowing staff to obtain as much information up front from the complainant instead of spending several weeks of back and forth communication to gather all the necessary information to conduct the initial review process. In terms of our investigation cycle time, also known as our Performance Measure 3, which is the bulk of your case aging when it comes to our investigations, we did conduct a 4-year analysis of our board's previously established 90-day target measure and found that PTBC's average has been 171 days for the past 4 years. We looked at our other boards and realized quickly that our previously established target was very ambitious in comparison to others, so we have set our new target measure to 180 days. To help with some of this case aging, CPS has implemented monthly reviews with staff. This is to be conducted at the end of every month with myself and my analysts individually. We are working on getting CPS staff also access to LexisNexis, which is a public records database, which will allow staff to look up information such as addresses and phone numbers of our licensees, and in addition, some witnesses that may be listed. This becomes extremely helpful in those instances where our licensees have failed to update their license, address of record with us, and weren't able to reach them. Currently, we do send some of our cases to our Division of Investigations office, also known as DFI, just for the purpose of some of this research. And so now with this newly established contract, we hope that CPS staff will be able to look up this information and will save the board time and money by doing so. In terms of our communication with our stakeholders, we have established monthly Division of Investigation meetings. These meetings will be conducted on the last Thursday of each month between myself and the supervising investigator over the DFI's Enforcement Support Unit, Ms. Melissa Doss. The goal of this is to establish an open line of communication between the board and the investigative staff to discuss enforcement-related matters that may impact both departments, case aging, and for an opportunity to discuss urgent and high-profile cases to keep them moving along and worked efficiently and effectively. We also continue to meet regularly with our AG's office and our legal counsel, who is present here today. On September 27, 2022, CPS staff and myself will be attending the National Certified Investigator and Inspector Basic Training course, which is an in-person training hosted by DCA covering topics such as the principles of administrative law and regulatory process, the investigative process, investigator safety, principles of evidence and evidence collection, the tagging and storage of evidence, interviewing techniques, overview of inspections and inspection procedures, report writing, and testifying in administrative and criminal proceedings. And then in November, we will be attending the NCIT Specialized Program, where we will learn all about the advanced interviewing techniques, advanced investigative analysis, and investigative report development. The last time that CPS staff attended this training was back in 2011. So we are hoping and looking forward to this new refresher course. On October 4th, as previously mentioned by Mr. Gadget, He will be participating in conducting an expert reviewer training program along with our staff. This training will be conducted via WebEx, and its goal is to onboard experts that are needed in certain expertise, such as floor therapy, and in certain counties where we don't have enough experts at this time. In addition, some of our current experts will be attending as a refresher. In closing, for CPS, as you can see, we have been extremely busy. Staff continue to meet each challenge each step of the way. They remain very flexible when needed and have been extremely supportive of myself in this transition phase. And now for our statistics, if you can please refer to attachment A and B, which are found in pages 113 and 116. For our yearly statistics, the board did receive a total of 308 consumer complaints this past year and 154 total arrests and convictions for a grand total of 460. These numbers are reported in your performance measure 1, which is your complaint intake. And as you can see with the spreadsheet, these numbers did increase by 13% in comparison to fiscal year 2020-2021. As Jason said earlier today, these numbers do fluctuate regularly, and this particular increase this year was expected as we are seeing the nation leading towards normalcy after a national pandemic. The target for performance measure 2, which is our complaint initiation, is currently set at 10 days. This is the average number of days it takes for PTBC to initiate a complaint and acknowledge receipt of the complaint. PTBC's average this past year was three days, which means that we are excelling in meeting this mandate by 7 days. For performance measure 3, which is our investigative time cycle, and performance measure 4, which is our AG case time cycle, case aging was a bit higher in comparison to last year. As mentioned many times, these numbers are known to fluctuate from year to year. That pandemic did make things harder to investigate with our investigators. And as we saw with Mr. Gadget's presentation earlier today, with his explanation, this is a very robust process that can take many, many months to complete, and one or two very complicated cases can definitely increase our numbers substantially. This past year, we did refer 47 cases to the Office of Attorney Generals for the filing of an accusation, and we did end up filing 29 accusations and 4 statement of issues. Lastly, CPS had an increase of 104% in the issuance of citations this past year. We ended up issuing 53 citations for fiscal year 2021-2022 in comparison to 26 that were issued the prior year. As a reminder, citations are being utilized for lower level violations and as an opportunity to educate our licensees in isolated record-keeping matters or in the instance where there was a failure to update an address of record. For our 3-year milestone statistics, we are seeing a total increase in the number of complaints. Again, as I previously mentioned, this does account in regards to the opioid crisis. We did see a slight decline in the year 2019 and 2020. Convictions also have declined in the past 2 years. However, there continues to be that increase in the average number of days to complete that investigation. We are seeing a slight decline in the number of days that it takes to the AG's office to, from the moment of transmittal to the final disposition. At this time, this does conclude my report for agenda item number 28, and I'd be happy to answer any questions in regards to our CPS program.
Appreciate the report. It's a very inclusive report. I see some changes, and just curious if some of these changes just came with you.
They did. I can say that for our consumer complaint, I actually was part of that process with the medical board and worked with a team of staff down there to revamp their complaint form, and that was one of the very first things that I noticed that I can work on the moment that I arrived.
Fantastic. Any comments from staff? Board comments?
Is there the option for the person filling out the complaint to comment on, this was easy, this was too difficult, something like, so you get some immediate feedback?
We can definitely survey our consumers. We do have the ability to survey them at the end of the investigation, and we can definitely include that in there. Just to kind of mention elaborate on the changes that we made, all of the fields have become fillable, so you could easily tap along. We did also increase our space to include more information if needed. We previously had instructions that they could attach additional pages for their summaries in regards to their allegations, but we did increase the spacing as well. That was one of the prior complaints that we did gather from the beginning when we were looking at this from staff directly.
Great. Nice to see that staff will be attending this training after some time not attend. Is this the first time it's offered in a while, or?
It's part of a departmental-wide move towards, as you board members might remember that we entered into a clear contract and we brought a quarterly training to you as members from Clear. Subsequent to that, the department entered into a department-wide contract with Clear, and so now accessing NCIT training for investigative techniques is much more accessible. And so just as part of that department-wide campaign, we'll be attending both of those days.
Thank you. Further board comment or discussion regarding enforcement? Any public comment? Thank you, Erica. Probation services?
Thank you, Madam Board President. Now moving along to agenda item number 29. This is a report of our board's probation monitoring program for the fiscal year 2021-2022. Please do refer to attachment 1, which contains the probation statistics for the year, and attachment 2, which contains the probation statistics for the past 3 years. These can be found on pages 122 and 123. For fiscal year 2021-2022, the board had 72 licensees on probation. Out of those 72 licensees, 5 were tolling out of the state and not receiving credit towards their completion of probation. There were 23 total licensees placed on probation this past fiscal year and 9 successful completions. Of the 67 licensees that were not tolling, 11 participated in the board's drug and alcohol recovery monitoring program. 6 of those 11 participants enrolled this very past fiscal year. We also had 6 total participants that completed the program successfully. There was an instance of a non-compliance matter in this very last fourth quarter with the probationer, and as they failed to check in to find out if they needed to provide a biological fluid sample the day, the licensee was sent a non-compliance letter and was given a warning that further instances of non-compliance may lead to further consequences and/or further disciplinary action. Over the last 3 years, there have been some fluctuations regarding the number of licensees on probation. This was partially due to the impact, again, that COVID-19 had on the practice, some in-house cleanup of breeze records, and the fact that some of our tolling licensees out of state let their license go delinquent for over 5 years and eventually enter into a canceled license status. Those individuals have been given secondary license status of non-completion of probation, and if they ever wish to come back to California and obtain their license again, they will be required to petition the board for a reinstatement of their license. All of this did decrease our overall number of probationers throughout the year. However, our statistics, as you can see, are showing that these numbers have slightly increased throughout the years. They rose from 9 licensees in 2019-2020 to eventually 12 in 2020, 2021, and a very significant jump this very last fiscal year to 23 licensees, resulting in an overall increase of licensees being placed on probation. At this time, this does conclude both of my reports. As you can see, both CPS and our probation program are thriving and carrying out our mission to regulate our licensees and protect our consumers in California. Be happy to answer any questions you may have.
I have a question for you, Erica.
Absolutely.
Under the Maximus statistics, what does failure to receive benefit mean? Terminated, failure to receive benefit.
Failure, oh, that is when it's deemed, licensee is eventually deemed after they started the program to not be beneficial once they start the program, and then they would report back to the board that they're no longer an considered a active participant that may benefit from the program.
Okay, so for clarification, determined to be clinically inappropriate is before they even enter the program?
Correct, that's
Gotcha.
before the CDE.
Where's Monty? It would have been great to have him here for the hearing.
Mr. Martin, one, I would say duly noted. Mr. Martin was not able to travel with us for this meeting, but he will be with us for meetings in the future.
Okay, thank you.
To your first question, the distinction between those two categories, though, typically when we talk about a probationer who enters Maximus, the expectation is it's going to take about 3 years for them to complete the program completely. There is an opportunity for licensees to ask for a second clinical diagnostic evaluation in the program. And in that second evaluation, if it's determined that they would no longer benefit from the program itself, meaning that they're no longer identified as a substance abusing licensee, they have the opportunity to be discharged from the program. It's not typical, but it does happen. And we do see, again, on rare occasion, that happen. And I will relay to Mr. Martin the observation of his absence.
Thank you for presenting on his behalf, Erica. That's something that many of us board members look forward to hearing from Monty. So we're glad that you have reported in his place, and I'm wondering if he's gone back to in-person interviews just yet.
We are looking at that, Madam Board President. We're hoping to have that established pretty soon here. Yes.
Awesome. Other board questions, comments?
Is there any budget allocation for a second probation manager now that we've moved to M?
So that's a great question, because we do have even aside from moving us to M, we did get through a BCP procedure last year an additional associate governmental program analyst position, which is the same as what Monty is sitting in now, for a second probation monitor. The pandemic kind of derailed our need to fill that position because we were relegated to telecommunications. We weren't traveling. We weren't going and doing site visits or anything like that for the probation monitoring program. And we've seen a statistical decline in the number of participants in the probation program. We'll revisit it. Right now, it is essentially a salary savings, right? It's a vacancy where we're not filling. It's a position that we haven't filled, so it has saved us some money, but with the current workload, Monty himself is able to do that. As we return to kind of normalcy in the pandemic state, endemic state, if you will, we'll have to kind of continue to kind of reassess the need for an additional probation monitor. And if we need it, we have the position authority to do it.
Other questions or comments? Any public comment? And on behalf of the board, it's nice to have you. Welcome. Thank you for bringing your experience forward and serving as the manager of enforcement. We're happy to have you, Erica.
I'm very thrilled to be here. Thank you very much.
You're welcome. Okay. We are now on agenda item number 30, which is public comment on items not on the agenda. And so I will invite any public comments for items not on the agenda at this time. And hearing none, let's move to agenda item number 31, which is agenda items for future meetings. This is an opportunity for board members and the public staff to offer any ideas on items that we might want to see in the future.
I have one for you, Alicia. So recently, I believe Gavin Newsom passed a law where now if cannabis use is happening after work, employers can't terminate somebody for that. I'd be interested in discussing that further with the board as far as how cannabis interacts with physical therapy, because there's products that are non-psychoactive like topicals and tinctures where there could be a medicinal benefit. And is that information in curriculums? I'm guessing not. And, you know, we're in a state where it is legal medicinally and recreationally. So is there a responsibility to educate our students on how to recommend things to patients or direct them towards where they can get more medicinal products?
I like the topic.
There are and have been continuing education program presentations on cannabis products and their relevance to the practice of physical therapy.
I'll just add from an academic perspective, haven't started seeing that topic covered in foundational coursework, but it is being covered in courses that address emerging topics. So it's being talked about.
There's a few things that we can do, informationally speaking. We can reach out to APTA and FSPPT both for any kind of presentations that they might be willing to do. And we can certainly invite our colleagues from the Department of Cannabis Control to get their buy-in as well. But we'll put that on the list for future events.
Yeah, I'm not sure that it would add into our discussion regarding this topic, but one that I'm curious about is because it can be used, it will come up on a drug test for employers, and some employers have, you know, regulations or policies in place, and so that's a real tricky topic for students and for employees as well. Great topic. Anything else you can think of? Anybody else? Items not on the agenda? You probably have already have this in the works at some point, Jason, but earlier in, I think it was the application and licensing report, Dr. Dominguez pointed out and asked about the ENMG and KEMG. And so anything that board members necessarily need to know and or discuss regarding that?
I guess informationally speaking, I can tell you that I have had conversations with CPTA as of late where we did bring in a few of the EN and EK license holders, just kind of talk about where the board is. One of the concerns is that being that this is such a small contingent of our licensing population, and it's somewhat on the fringe of a possible change in the Practice Act, right? So one of the issues with EN and EK at the time that it was formed was the prohibition of tissue penetration in the Medical Practice Act. And so as we're looking into the future and the nation is considering other modalities such as dry needling, EN and EK will get kind of lumped into that conversation. As we kind of talked about earlier, and the question was asked specifically, the last time we received an application for either of those two was in 2018, and it was just that single application. The examination that we proctor for both of those specialty daughter licenses is rather old, but doing a psychometric analysis and establishing a new examination is really quite costly, really expensive. And the demand for that examination has been extremely low. And so it's kind of sat on the, on the side table a little bit as far as priority. And that was one of the conversations that we had with CPTA, is just kind of let them know the hows, the whys, and they understood, given the context. Whether or not we go forward with contracting with a vendor or the Office of Professional Examination Services in the future to develop a new form of that examination will really hinge upon that greater conversation as to whether it's even necessary looking into the future when it comes to the Practice Act and tissue penetration and the conflict with the Medical Practice Act.
Thank you for that. Other ideas for future agenda items? Will staff be bringing in December any ideas for regs to work on for the next year, or is that not the time?
We're always open to ideas. If there's something that you've heard through stakeholder feedback or anything that you don't think is on our radar, please bring it to our attention. Continuing competency is certainly the largest one that we're looking at right now. Although when I say largest, I don't know that the recommended changes to the continuing competency regs are going to be that substantive. There's a few little things that we would like to tweak, but we think the package in general is really sound and it really provides enough flexibility to the licensees. But again, we're open to any other recommendations that you as members might have.
Okay, anything else? Any public comment? And we have gotten through the entire agenda, correct?
We have.
Good work. Thank you all for being at our first in-person meeting since December. And be well, and we look forward to seeing everyone in Sacramento. And the time is 1:12. The meeting is adjourned. Thank you.